Attention item number 16 and 17, supplementary list Lordship. In 16, I am the petitioner. I am the respondent Lordship. In 16, I am the respondent, and my youngest friend is the petitioner side. They are supposed to file the affidavit in reply today, but not yet.
They have not filed. Very good. One should be happy.
Lordship,
The petitioner is unwell. Unable to come down, Lordship is unwell. So contacted him, Lordship is unwell.
16 and 17.
The petition can be given by the time Lordship will come down.
What is the matter about?
Matter regarding promotion, Lordship.
Promotion to?
Chief Administrative
City
Officer.
officer, Lordship.
There is stay operating.
No, Lordship.
And 17 matter also, Lordship, I have taken
Who is
step
working as the chief?
on my respondent number 6.
What is your ground? Ground of challenge.
Number 6, the establishment that was serving at that point of time, Lordship, that was not a part of the original. So,
It is a promotion and post Lordship, and thereafter advertisement was made by the district judge Karimganj Lordship. And accordingly, after interview, he was selected. And because I am Lordship going to outside for my treatment today, that is why I must. Actually,
But I fixed this matter
yes, Lordship, yes.
on that day.
Yes, yes.
Then
I do not have, because due to time, Lordship.
oh, the council is appearing on behalf of the petitioner as well as the respondent. I'm not inclined to do the matter. Considering the above, it's the matters, these two matters stands adjourned Sinai. Won't come till I don't give the permission.
the Lordship will kindly give us 2 weeks time, Lordship.
No, adjourn Sinai. Won't come forever. Till I am holding this bench,
Lordship,
it won't come.
Lordship, in case number 17, Lordship, in case number, I have taken steps yesterday. That was in Lojima court, Lordship. I have taken step.
I don't
What
know.
is purpose?
Because Lordship, even we have not received the.
It is adjourned Sinai. It won't
Lordship,
come.
would not vote the
How many
matter.
years of service you have?
Lordship,
How many years of service you have?
that was more than 15 years, 20 years. Like that.
How many years of service? You are the chief administrative officer, means it is at the highest in the district,
Yes, Lordship.
isn't it? So how many years of
I am
service?
paying for any rate.
I am asking you, how many years of service you have?
About 21 years.
And
Chief
you are
Administrative,
at the
as
highest
a chief
rung of.
administrative officer, 3 years. He was promoted on the
When are you retiring?
now he is at 48 years.
You come up after 12, 13 years.
And second matter, Lordship.
I just require 2 weeks time, my Lordship, to file my appeal, Lordship. The petition is unwell, your Lordship. Because out not of made this prayer, Lordship. Lordship, fix it after being your Lordship will file a affidavit in the meantime, your Lordship. And we have also not received the
Council
copy of.
appearing on behalf of the petitioner in WPC number 6907/2023. As well as the petitioner, as well as the council who appears on behalf of the petitioner in 2207/2024. Are both not inclined to do the matter, in spite of the fact that the matter was fixed by the court for today for disposal. Just taking into account the above, is the matter about the matter is these matters list these matters. The matters stands admitted. The rule is issued. And this the matter for hearing in the usual course. Interim, there's no interim order.
No. Okay.
May I please proceed?
Hmm.
Item 80 lawsuit, we have filed a equitable lawsuit, so lawsuit bring on record lawsuit.
With concerning the other side, with concerning the other side, I think item number 8, 12 and 13 above. If this matter would be taken up any day of next week, never. My senior
Eight.
counsel has 8, 12, 13. My senior counsel out of the station.
Who is out of station?
Yes, 7.
Who is Ashwama? Oh. 8, 12 and 13. Item number 8, we admit it. We issue rule. Who is appearing? We'll adjourn, we'll accommodate you, don't worry. I won't dispose of these two matters. 12 and 13, this is the matter was taking into account that the counsel for the Guwahati High Court have sought for time, and the counsel appearing on behalf of the respondent petitioner have not objected to release these matters for hearing in the usual course. And item number 8 will be admitted when the matter comes up, and then fix it for hearing in the usual course.
I get you. So this thing is ISL, the worship of ISL.
Hmm. For what? No, go there. There's another court. I am the junior most in this bench. Don't mention it here. Go there. Ah.
Lordship, I beg to mention item, item numbers 1, 2, and 6.
1, 2, and 6.
Yes.
Why?
Lordship, my senior, Mr. A. Somo, has currently had to travel out of station for some sort of emergency. Lordship, moreover, with item
Other
number-
side had no objection. We have no objection.
Item 1, you also will remember he was asked to produce that certificate. Full certificate, there were, yes, Lordship. That certificate has not been able to be produced in our Lordship by the petitioner.
No, we'll let us take up these matters. I will accommodate, I will issue rule and admit it and fix it for hearing in the usual course. And the matter is. So, if you are not inclined, why should I be? Only thing is, if both the parties are agreeable, why should I spoil my unnecessary time? Other times again.
For admission, item 1.
Yes, you want adjournment and you have no objection. The counsel appearing on behalf of the petitioner submits that in spite of opportunity being granted, the petitioner have not been able to produce any certificate to the effect that the certificate in terms with the order dated 27/1/2025. Consider the learned counsel appearing on behalf of the petitioner seeks for accommodation. The counsel appearing on behalf of the Guwahati High Court submits that he has no objection. Considering the above, the instant petition stands admitted. Full stop. Rule is issued. Extra copies of the writ petition be again served upon the counsels appearing on behalf of the respondents. Full stop. During the course of the day, full stop. List the matter for hearing in the usual course.
Item 2,
What is this matter about?
Lordship, this matter was with regards to a particular service related issue wherein we were seeking for the quashing of an order that was dated the 29th of December 2022, which was passed by the learned Chief Judicial Magistrate in Nagaon. Lordship. Wherein the petitioner was said to have been not
So
eligible
your
for the.
appointment has been rejected
Yes, Lordship.
on the ground that you are overaged.
Yes, sir.
You filed this writ petition in 2023. Order of 20 to 2022. We will admit this petition. Matter will come up in the year 2027. I hope by that time something will be. You have no objection. The counsel appearing on behalf of the petitioner seeks for accommodation. Taking into account that the affidavit in opposition has been filed and there is no reply filed. The instant petition is admitted on issue rule. The counsel appearing on behalf of the petitioner is directed to serve extra copies of the writ petition upon the counsel appearing on behalf of the respondents during the course of the day to list the matter for hearing in its usual course.
3,
Yes, the matter where, as regards the stenographers of the subordinate courts, but the rule was not framed by the.
You want also to admit it? By the time I retire, this matter will happen.
Because of the matter, because only thing.
Your entire case was on the basis of the Stenographers Act.
No, my lord.
which is
My
not
case is
applicable.
also on the basis of a Shetty commission where the Supreme Court has said.
No, SETI Commission or no SETI Commission doesn't say out there. Your entire case was on Rule 6 of the Assam
My lord,
Stenographers.
they have for a one-time measures in the 1819, they have taken into consideration the High Power Committee said that the Shetty Commission, we have looked into the Shetty Commission, but relaxing this rules, we have given as a one-time measure. Now that cannot be a notional extension for an indefinite period without any notification being issued. That cannot be continued for a notional extension for an indefinite period without reason. That will be arbitrary, my lord. And the Supreme Court, my lord, the reasons they have shown in the affidavit they have filed, my lord, the High Court, my lord, at page, your lordship may turn to page 72.
Yes.
That is the High Power Committee, my lord, where they have said that.
Promotion of the existing stenographer of the subordinate judiciary, the committee recommends the following criteria as a one-time measure pending subordinate courts establishment rules of 2000.
And my lord, as regards the Shetty Commission, next page.
In educational qualification, they possess existing. Have completed 15 years. Grade 1 subject to the. So this is a one-time measure.
One time, next page, your lordship will find, they have also stated in third paragraph, the joint committee perused the report of the registry regarding the recruitment of stenographer of all grades of subordinate duties.
But this is one-time measure pending framing of subordinate court
Rules.
establishment rules.
My lord,
Now,
they-
these rules have not yet been framed.
And my lord, for a notional extension, my lord, automatically they are keeping on doing all this, my lord. Notifications are issued, there is
Can't
no-
help it.
again in 23, 21, my lord, at page
So under
74.
such circumstances, under Article 235, the High Court exercises its power in terms with this resolution.
My lord, then, my lord, without looking into due respect, my lord,
No, first of all, for the stenographers of the subordinate judiciary, is there any rule?
no, my lord, there is no.
So therefore, the High Court can pass executive instructions.
My lord, the High Court can pass executive instructions subject to, my lord.
Now, what the High Court is saying that this aspect of the matter which was there at
Hello.
that point of time, they were under the impression that the High Court rules, the subordinate court rules will come up. This framing was
Whether-
given in the year 2018. They thought that within 7 years, 2 years it will come, but the government is sitting on it.
Madam,
Because of the
whether
fact that
before the
Guwahati High Court is also
notification,
sitting on it.
Whether before the 23.
Anything done? Mr. HK done.
It's going on.
Going on. See? Is going on. So till then, the court has
But-
the absolute power and the
But
245.
whether there was any committee recommendations or something like that, like whether notification, whether under 235, it was in page 77 in 2018. Thereafter, there was nothing, madam.
No, then on what basis you have a legal right?
But-
Tell me.
My lord, the basis of my legal right is this, the procedure of what they are following as a one-time measure cannot be in an optional extension.
But that one-time measure is also supplanted by till the subordinate rules are framed.
My lord,
Why do you pick only one word, one-time measure,
one of the
and not the
reasons why
other?
not, they are not applying the Shetty Commission when the Supreme Court has suggested them to apply that. Why they were not applying the Shetty Commission report? That was not the reason shown. That is why they are saying one-time measure.
Where's
Supreme
the
Court has-
City Commission's report? Let us see, what does it say about stenographer?
My lord,
doing this?
That I have annexed, my lord, your lordship will find that page.
Where? You file some affidavit?
Page 37. It starts at page 36. Recommendation relating to Assam.
Chapter 10, we have considered the importance of the eviction stenographer for Great. Very few direct, very few motion. By 50%. Direct. So this is the
My lord.
City Commission's recommendation.
We are grade 2. Now from 129 candidates, there were 89 candidates from grade 3. One was rejected because he did not completed the year that has to be completed. So he was rejected. Virtually from 128 candidates, 89 were from
But
grade.
tell me that each City Commission, High Court is bound to follow.
Well, the judgment I have given, my lord, over there in the Supreme Court judgment was there already. So, my lord, I can place another judgment, my lord.
Please. I am new to this subject. Please.
Lord, thank you, my lord. Because, my lord, it's a type copy, behind that, that was the Supreme Court judgment. Court has directed
So as per the High Court on the administrative side is required to go as per the City Commission's recommendation.
And for that reason, from 2018, there was a one-time measure. Then in 12 one-time measure, 18 one-time measure. Then for a notional extension, my lord, automatically it has been given. There is no such why it has not been implemented, why the Safety Commission is not recommended. That was one-time measure in the affidavit filed by the High Court in 2018. And the last advertisement was given in 2023. Huh? 23
So
in
you are challenging the
advertisement along with the notification and the selection. Both.
Where are you challenging the selection?
My lord, you also will find a page in the prayer portion. Advertisement notification dated 21/3/23. Annexed to page 13.
Where are the selected candidates of, yeah?
My lord, and at page 14B, the writ of search should not be issued watching the improved list of eligible candidates, page 24, 28.
Where are those people?
My lord, because my lord, going down my head and with due respect, my lord, when the institution is carrying on a selection, it's not necessary to impede all the parties. If the institution is impeded, that itself will take care of all the selected candidates. That was a division bench judgment subject to all my restriction, my lord, from the side. This is.
So I will have to set aside somebody's selection without making them up, without hearing them.
My lord, that was what I find, my lord, subject to all our place practice. What the judgment is. My lord, it is the 2012 to GNT page 893. My lord, it was about the non-gender of parties when does not constitute, and my lord, selection process challenge. And my lord, the relevant paras are, my lord, I'm placing it again. Now it starts at page 901. Some of the words which I have taken from the dictionary because used by Justice Amitabh Roy, my lord, I have.
Don't make a judgment, what is that?
The 2012
See, if it is in gross violation to Article 14 and 16. If it is in gross violation to Article 14 and 16, then there is no
My
requirement.
lord, one judgment I found yesterday, but it was of 600 pages, so I could not read the whole. My lord, what they have said in that, if my lord, it is arbitrarily without reason, they have taken notional extension of year after year. Automatically, they are going on taking the notional extension. Then it violates Article 14 and it is arbitrary in nature.
Tell me what is the name?
Our name is Sapam Jiten Singh and others versus Manipur Public Service Commission in
Yes.
2012 to
What is the
28.
name?
Mala?
Name of the party?
Sapam Jiten Singh and others.
Spelling?
SAPAM,
PAM.
the PAM, JITEN
Tapam Jiten Singh.
Singh and others. There are 20 man.
Thousand 12-6 ZLR.
In GNT page, it is para 20.
No, this is Professor Singh. No. You want a division bench?
Division bench. Justice Amitabh Roy and Justice Mrs. Indira Shah.
This is Manipur Public Service Commission.
Mal. The constituency versus Manipur Public Service.
Is one. In Singh. No other.
Only one.
And others. Sapam Jiten Singh and others.
It's not there in FCC.
Not there. Yes.
How do I get it?
Yeah, my lord, can I get this? As I remember, but para 20 on board.
See, no relief directly claimed against the selected candidates.
But here the issue is also we are not claiming, but the
You are asking that that select list where these people are there should be set aside. Not paid, yeah. And this is a challenge on the ground of irregularity in the conduct of selection process.
well, here also we are saying a lot that
It is not irregularity because here there was rampant corruption in this Manipur Public Service Commission. This is the basis on which it was being done.
para 21.
Supreme Court also in Bihar Public Service Commission case.
The
Similar.
prospectus of the implement and being regard to the okay, it's so much. It's more. Now, just for example, I give you that you are entitled to promotion. Fine. Okay. Now, if I give you that entitled to promotion, I have to give you the promotion from the date on which these people have been there. Either. Or I have to relegate those people down. Well, either. Now, those grade 3 stenographers would not be affected.
Here, our case was that, Madam, that if the same first notification that was issued in 2023, if that goes, Madam, it is for the High Court to decide what they have to do with them. Because the notification, you have challenged first the notification, where they have said from grade
So
three can
you
go to
want
grade
that-
2 also and
You
grade 1.
only want that notification to go.
Notification also.
Notification means the advertisement.
Advert.
Now, if the advertisement goes, you are as if you are sitting in, as I am taking bench 1, it is like you are asking for a declaration without the consequential relief. Why should I give it?
My lord, here,
Isn't it, Mr. Ghosh?
my lord,
Isn't it something like that? Isn't it a declaration like without a consequential relief? You are asking the advertisement should go, but the others should remain.
my lord, other things, my lord, if consequential relief is this, my lord, if the notification goes, everything goes and my lord, only the grade 2 will come to in the place. Subsequently,
But can I say that the others should go?
my lord, if on the alternative, if I can pay, henceforth, my lord, there should not be any notional extension on the basis and the
Or henceforth I can pass an order without those people being included, that henceforth, without implementing city commissions,
my lord,
they cannot do so.
my lord.
Hence, not
That-
prior to.
Not back, my lord, that I also
Then
understand.
nobody is affected.
Not, my lord, at least henceforth, the.
What do you say, Mr. Das?
The first submission is that one of the petition, that is petitioner number 1, he himself is a beneficiary of this process, whatever decision. That your lordship will find.
That I know. The
Yes.
fluency is still out.
Yes, not so that is. And so far as the decision resolution taken by this honorable court in the administrative side is concerned, if your lordships kindly consider page 72, the safety commission's recommendation was considered by the committee in the administrative side, and thereafter decision was taken to fill up the post of stenographer grade 1 by relaxing the norms because there was no sufficient incumbent in the feeder cadre. So, and ultimately the selection will be done on the basis of screening test and suitability.
Again, henceforth,
So,
another
it
advertisement
is-
came up.
It's not
Again, this,
the speed test will be conducted and thereafter they will get the promotion. It's not that they grade 3 and grade 2 club together and will not unanimously will not, they were given promotion. They will subject
I
it.
understand. But the thing is, Supreme Court had stated that the high courts in the administrative side are directed to this. So maybe at that point of time in 2020, you did not do it. What do you mean? But don't you think from henceforth you are required to do it?
Definitely, my lord. So that's why this decision was not final. This decision was subject to finalization of the rules. And lordship is aware that rules are in a state of flux for.
No, whatever may be. Your rules may not come up. But henceforth, you are therefore mandated as per the order passed by the Supreme Court in this case on
all the judges,
this order dated 7/10/2009.
Not this, I haven't also in entirely.
I'm giving one.
But I'll have to confuse because it doesn't say which are the recommendations. So all but all the recommendations were not, so far as I remember, because in one of the case I have came across. Ethics commission was pertaining to paying allowances of the basically. The safety commission's recommendation primarily was confined to the pay and allowances of the staff of the subordinate judiciary, which were strictly followed by all the high courts and implemented. And this was directly to be implemented by 2003. And our resolution, which will also kindly have page 72.
Year of 2020, in
Yes,
1920.
it is taken care of, the safety commission's recommendations were taken care of. This is regarding filling up of vacancies of stenographer grade 1 and stenographer grade 2 in the subordinate.
Let us read it properly.
I'm sorry. Page 71.
For promoting of existing students. Modality
The
of
modalities
promotion
for
is
promotion of stenographer as specified in resolution dated 6/3/2013 of the Honorable Committee for Consideration of Safety Commission's recommendation on revision of pay scale, etc. of the subordinate court staff of Assam is quoted below. For promotion of the existing stenographer of subordinate judiciary of Assam, the committee recommends the following criteria as one-time measure pending framing of the subordinate courts establishment rules of Assam, irrespective of any grade, education, or qualification with potency. Existing stenographer who have completed 15 years of service is promoted as grade 1 stenographer, subject to such criteria as regards speed test, etc., which the High Court may fix on availability of vacancy. Irrespective of their education and qualification based processes, existing grade 3 stenographers who have completed 5 years of service be promoted as grade 2 stenographer, subject to.
Now, where do I get this 27/2013? That is the most important document.
27 will also be referring to.
In that thing, you see, this resolution
I
which
have-
is being
I am-
adopted is on that way.
One second.
Promoting of the existing, the recruitment shall may follow the relaxation criteria adopted in full. The joint committee reviews the proposal list. Now kindly see, page 72.
Yes, madam.
The recommendation of the SETI Commission regarding mode of recruitment of stenographers in all grades was accepted by the Honorable Supreme Court by judicial order. Thus, it is imperative that the stenographers are differently be recruited in the following manner.
Yes.
So this is what they have done.
Yes, yes. It
It
may
may
be
be
stated-
stated that the said relaxation criteria was followed while giving promotion to the existing stenographers in the two promotional process completed by the district year. it may also be mentioned here that the subordinate so-and-so is under consideration of the government of Assam.
And same is awaiting gazetted.
The pertinent to mention that even after conducting the promotional examination on year, substantial number of year posts in the visa could not be filled up owing to non-availability of the year. In view of the creation of so and so. And now, okay, you can very well do so. Now, there might be a case of relaxation, which you may have to, in fact, what appears from here is you have on the ground that you are not having adequate eligible candidates. So you are also extending the zone of consideration to grade 3.
That much only.
That appears to be the subject. Now the question is whether you brought the petitioners out here who are grade 2 within the zone of consideration.
Everyone will come. Grade 2
No, not everyone will come. My question is specific. Did you bring the petitioners within the zone of consideration? Because they would obviously come within the zone of consideration because they are grade 2. So you have also proceeded to make it grade 3. Now what your AI is not only the promotion is not on the basis of seniority.
It's not.
It is on what basis?
Screening test and suitability. Screening test.
So screening test and suitability. Now the petitioners did not fare well.
Sorry.
The petitioner may not have fared well. So therefore the petitioners were left out. So here the petitioner's grievance is, if those grade 3 were not there,
More competitive.
no competition, but could
No
the petitioner have got in then also?
Same thing.
The question remains as to whether if you are not satisfied with the suitability, could you have got it?
Had there been those grade 3 would not have been there, then we would have come in, my lord.
How?
But because we have also applied for that because our marks were.
No.
Because my lord,
Counsel.
your lordship will find that the at page 83, your lordship will find. 83, your lordship will find what they have done. Voice testing for before dictation 2 minutes,
On
page 83.
yes.
Speed test in shorthand, voice testing before dictation 2 minutes. Speed test in shorthand at the speed of 80 words per minute. Time to be given to the candidate for testing the computer 3 minutes. Time for testing. So there was a practical test over there. Then, my lord, it was held. So when the marks were raised, my lord, the grade 3 candidates who scored more, they came in. Our question.
No. Minimum you have to get 30.
Minimum we have
But if you have not got that
candidates securing
30,
30 marks out of 50 will be eligible for promotion.
no, I'm not there. Now come to number 5.
5.
Candidates securing 30 or more marks out of 50 will be eligible for promotion. So if you have not got 30,
My lord, then we
what
have.
business you have?
We have
You are asking that you are asking similarly simple something like
my lord, now
I will
I
have
take
to
your
do-
lordship because we have been asked to come for interview also because. We are asked to come for interview. We have got 30 marks, my lord.
they got 30 marks.
My lord, and we
I
have
don't have any insight.
marks. Marks we have not admitted, my lord.
No.
There is no interview here. Where is the interviewer?
Advertisement says only screening test. Only
Voice testing before dictation. Speed test. So and so. So this is total 50 marks.
there is no.
You get 30 marks, you go. Your only thing is, if the grade 3 was not there, I would have got 30 marks.
So that cannot be mine.
If that cannot be, your case falls like a pack of cards.
Or the only thing that I am asking for, my lord, they should at least go for a high power committee discussion that I am electing for this time. But that cannot be a notional extension for one-time decision and it will keep on continuing for indefinite period. That way there will no rules will never be framed and this way it will keep on going on. So grade 3, they get a
First of
chance.
all, you don't get 30 marks out of 50. What will I do? Tell me.
My lord,
If you don't get 30 marks out of 50, how can I help you?
My lord, only thing is that we are challenging the notification because my lord, grade 3 are entitled to go for grade 2 also and grade 1 also. So my lord, their way, the grade 2 will remain vacant forever, my lord, because grade 3 will all jump over to grade 1.
Grade 2
Nobody-
will be vacant.
Because only 50% from direct and 50% from promotion. So my lord, 50% for promotion, they will all go for grade 1. They have never gone for grade 2. My lord. They are not going for grade 1, grade 2. They are going for grade 1. So that 50% will remain vacant.
There is a test for grade 2 also. He has
Yes,
to got 30. He has to appear.
My lord, what they are doing because the notification that is there at page. my
No,
lord,
no, Mr. Kindly come to this page 83. If you are going to get 60, 80 words per minute, then you are good for grade 1.
my lord,
But if you are 60 words per minute, you are going for grade 2.
my lord. Yes,
Time to be given to the candidate for testing of the computer. Same. The only difference is between both is 80 and 60.
Well.
That's it. You get 80 per words per minute. Very
the
well.
thing is there, my lord, that I have failed in the examination. That's true, my lord, because I have not got the instruction whether I have passed the examination or not. Whether that, if my lord, their total vacancy was 129. My lord, now how they have taken, all the persons who have above 30 would have come for 129, my lord. That cannot be also possible. If, my lord, if all the person who has passed 30 are entitled to go for the vacancy, total vacancy, the number of candidates will be more than the vacancy. So all cannot be there. So there is some kind of a cutoff mark where some candidates were placed in higher position because the marks were more than the others. It is maybe the situation. That record has to be got by the management. That whether they have taken into consideration, because if all the candidates of grade 3 and grade and they have applied for the test and they have got
Mistakes. Your case. Your petition.
that reading is not there. But my lord, as your lordship has asked me the question that you have not passed 30, my lord, that aspect of the matter,
Now, I get you. You say that I may have got more than 50, 30
my lord,
out of 50.
my lord,
But there might have been other candidates
who have got 70.
I was not given. So the question is, did you get 30 or not? Because if you have got 30, you see, if you have got 30, as per this particular document at page 83,
My lord,
candidates securing 30 or more marks or there would be eligible to promotion for and
and my lord, your lordship may also consider the page 20 in our petition.
so 2 minutes voice testing. That
And
is
the-
same for both. Time for AI is 3 minutes, 20 minutes. You have to get only 30 marks out of 50 in this.
And my lord, in the total number of in the year 2023, total vacancies were, my lord, 81 around. That was in the advertisement, page 20. Page 20.
So this advertisement which is there in 2020, that is grade 1 36, grade 2 30,
That
20.
was in 20. Our case is of 23, my lord.
23,
23. Page 20.
23, 23.
Vacancies are 11 and they are 781.
Only 5 these marks.
And the total candidates they have taken is 129.
Wait. This is of the speed test held on 10/6 mark. So how many posts were there?
Total of in
Grade 1?
grade 1, my lord, 52. Page 20. And my lord, grade 2 is 29. And that, my lord, the list is at page
86.
86. Page 24, your lordship will find eligibility list. Our names are there in serial number 48, 83,
Page 20. Applied for grade 1. How many people?
total, my lord, 129.
And out of that, only 43 got it. Huh? Only 43.
My lord, here 129 and total, my lord.
Only
One was rejected.
Only 43 got it. 52 out of 52, only 43 got it. And what is this, Mr. Das? Kindly come to the number of posts of grade 2 is 29 at
Yes.
page 20.
Yes.
And at page 86, you have the select list.
Yes.
Of which you are having for grade 1 only 43 out of 52.
Yes.
Okay, and then comes for grade 2, you are having 38 out of 29. As they were grade 2, they did not participate for grade 2. What is your name?
My lord, my name, one has only number one.
Number one has already got in the, is that,
What is the name of the patient number 1?
Tulosi Dev Sharma.
Tulosi Dev Sharma.
Page
Tulosi
86,
Dev
madam, serial
Sharma.
number
Yeah,
7.
he's number 7. So why have you challenged that?
My lord, during that time when we filed, my lord, that was not done.
Okay.
Subsequently, the affidavit came.
So do you want to go down now?
My lord,
If I set aside the advertisement, you will go down.
my lord. That is why my prayer is, my lord, henceforth, what they have to do, my lord, they have to take into consideration the safety
So
commission.
you are subsequent.
Subsequent, my lord, subsequent, because now, my lord, again, necessary parties and others will come in.
That is the big problem.
My lord, our challenge is only as regards the persons of.
And what is the other two names?
Other two names are, my lord, Jayad Usmani Lashkar and Nazrul Islam Lashkar.
Jayad Islami Laskar. Where is he?
Page
Yes.
25,
25,
48.
48, and page 26, serial number 80.
Your name is not here. In
Hmm?
grade 2. Because you are already grade 2.
Grade 1 of our name, sir.
Grade 1, you are not there.
Yeah, yes, my lord, page 24, your lordship will find
It's 24. No, that is the
eligibility candidate.
eligibility. I'm not on that. I'm only on the other one, the select list. You are not there.
My name, two and three are not there.
So you did not get that. So you say that if these people would have been there, not there, you would have got it. That is impossible.
Not henceforth, only that I can understand, my lord. That much, only thing is that they should at least consider that notional extension without any reason is argued.
No, this must have been because this appears to be that meeting where they have duly taken note of that this approval has been granted by the City Commission and the Supreme Court had directed for implementation. It was only under such circumstances this was being given. But in view of the creation of new posts and non-availability of sufficient numbers of stenographers meeting the above criteria till date, there are several posts of AI and grade 2 lying in the district. However, the vacancy position of the Imam will be. So they thought of relaxing it.
But my lord, 52 posts, only, my lord, in grade 1, total 43 were given. 9 was left. 9 has left.
Huh?
Because total
9 could not be given because those people did not succeed.
Yes.
Can't help it.
and my lord. Yeah, total list was there, many from the grade.
All said and done, Mr. Chaudhary. Coaching is nowadays, you have to go into the question of merit. Any of the marks is there, but merit is the most important. That is the problem which I am facing with these people. The government, they are not making the rules of the subordinate. But they are taking steps. But our High Court is a bit late.
2003 and 25, madam. 2003,
But 2003.
when the Shetty Commission says that you should implement it because the rules were not there from since then. If I take it from there also.
No, no, rule was there from 1987, but the stenographer was not inside this. Because 87, the judges used to write by hand. Yes. What to do, dismiss?
Not only some observations that if the High Court committee take into consideration, the relaxation should not be automatic. There should not be.
They have given reasons out here for the relaxation. This was done when?
It was in 2020, madam. Last was it was done in 2020.
No, this resolution was taken in the year when?
2020.
No, this
No,
is 72.
First resolution is of,
Then there is another resolution taken.
yes, number.
When?
2016, and in terms of that, 2018, page 74.
It is on 2018.
Relevant portion, my lord, will find page 75. In terms of the previous resolution,
So this was there.
yes.
And
Then,
it was also a one-time.
then, how do you go for the next one, next recruitment in 2023 without again not doing it? Again, one time measure, no resolution.
No, thereafter no resolution, thereafter notification was issued in
So
2018. my lord.
isn't it required for you to consider?
Thereafter 2018 notification was issued, same manner below selection was held, page 77. Then 2019, there is a notification,
Page,
page 79, my
so
lord,
we are concerned with this one.
23. Yes,
Page
then
23.
page 82, there is another recruitment. Because,
No, no,
where-
we are concerned with 23,
yes, my lord.
page 20, which
Yes.
is there. Now, 20, before that, did you take into consideration this? So if you want to relax, normally you are bound to follow safety commission.
Yes.
You want to relax, you have to take a conscious decision. Where is your conscious decision? No,
In 2018, the committee taking into consideration has, resolved that this has to be relaxed, and in this manner,
understood. Can the relaxation be means against the safety commission, which the Supreme Court has directed to comply?
there has to be some office.
And this is apparent from page 72 itself. In that resolution, which was made in the year 2016, that resolution categorically mandates that we are to follow, but here, kindly look here, that we are in these new posts are being created, and there are insufficient candidates in grade 2.
Correct.
Or grade 3, or being promoted out there. That is why we are doing it.
Yes.
So every time, if you want to do for 2023, you are to follow city commission. There's no quarrel with that.
Yes.
You are to follow because that is the mandate under 141. So if you are to follow, you have to follow, and it seems the High Court is aware of the city commission and it's given in that report. But if you in 2023, you don't do it, means you want to do it, okay, again you have to give reasons. The judges out there cannot be lethargic. They no. 2018-16, it has been done. So why should we have it?
2018, it was only
Because
for
just-
one-time measure. 2018 also one-time.
That is what I'm saying only. Can be every time a one-time measure, taking into account that it is required in the circumstances to relax. But in the 2023, they did not exercise that power and relaxed it. Advertisement is wrong, but we are not setting aside the advertisement, the notification, for the purpose that this will affect in large scale, and the petitioner did not qualify. But you are therefore going to have to take a conscious
Application,
decision.
Lordship is correct. It cannot go on eternity. There has to be application of mind. This,
Every time.
before 2023 also, there has to be application of mind.
That was
That
required.
whether we are required to follow, whether the rules have come or not, or
No, not only the rules have not come, there is no quarrel with
whether
that.
there are sufficient,
But that
yes,
because of this situation, a situation has arisen.
correct.
Because of which we
Whether that
require
situation is
that
still
in order
persisting
to
or not.
fill up These are so many candidates are there. These are so many posts. And against these posts, these are not so many candidates are there in grade 2
Yes.
and grade 3. These are there. But it will not be possible to create grade 1. And which will lead to again another problem of inverted triangle.
Yes.
Or prism or whatever. It will
Correct.
be.
Correct.
So that is why some decision has to be taken. And on the basis of that, the notification activation.
Yes.
will be done.
Whether that situation still persisting or not, that was in 1920. That has to be.
Because this would be otherwise you are violating the Supreme Court's order.
That's true. No. That's true. So it has to be there in the records. Because
So I
in
think
the affidavit, it's
we
not.
may have to dismiss, we dismiss the petition of the petitioner on the ground that this court is not going to interfere with that aspect. But the fact that this was not, decision was taken out there, we should remind the High Court that they have to take each step because this is the mandate of the Supreme Court. This is the mandate of Article 100.
Lordship observing that, if I cross-check with the records and I just satisfy myself, or for your lordship satisfaction, whether any exercise was undertaken.
Any
to
exercise are
ascertain
undertaken. Because
whether
you
the
don't say
situation
anything in
persisting
your
or-
affidavit.
I understand. And
Otherwise, he cannot say anything because he did not get the 30 marks.
lordship is
How
correct.
would you know?
Correct.
But this needs to be done every time.
Yes, yes.
Because otherwise,
Because
it will be
that
violating the High
situation
Court.
has to be there to follow that thing.
So, what to do? They dictate
I-
now.
I'll just at two and just have that record.
I'm very busy with civil bench 1 matters.
Oh, I'm sorry.
I don't have matters of Guwahati High Court more.
Then
I've adjourned many matters today.
I'll check the records and reply to your lordships or the court master regarding that.
No, because I dictate out to here now. I don't do it. Yeah, don't expect this matter to be taken back.
I understand. But without,
There is no question of a CAB.
No.
we'll
Do you want these directions being passed? Is the question.
next record.
Or we can do one thing. See, whatever may be, nothing is going to happen out there. No heavens will fall. We'll have it on 24th of April. Today is 20, no? Okay. Today is 20. We'll have it on 27th.
It will be even partnered because
It is, it's not the question of partner, no partner. This bench is with me.
Hello.
I have been
We
specifically
are obliged
explained
for
that.
that. We are obliged for that.
So, but this, if you don't want the direction, it won't be direction. This court will have to observe that you have violated the court's order. Supreme Court's order.
Perhaps that will not be important. But I'm confident that there was a process undertaken to ascertain. We will not work with so much.
Because every time you have to do that.
Yes, yes, my lord. There is no
Cannot,
quarrel about that proposition.
cannot do that. And it must have been, if it was not done, it must have been the
If
fault
it's
of,
not there, then my lord,
if it
observe.
was, it must have been the fault of the basic.
I just check the record.
Normally, on the administrative side, whenever these things, anything happen, all decisions are being taken and it is being placed by the registry before the committees. So the most probably the registry may not have placed it. And this fault happened with the register.
But it was placed somehow, my lord.
Establishment
No, will be by
This is
the.
of the lower court, I mean subordinate court. So this will be not the, will be the establishment. Establishment, recruitment, the register, administration.
Administration.
The qualities of the register administration. So the establishment is only for the High Court. If he has not penalized in department elections against the then registered,
Without hearing further.
so that is the High Court's, Supreme Court's order being violated. What do you say?
I'll check the records.
The matter again on 27. The matter had been heard at length. Footstop. The only issue arises the instant proceeding as to whether any decision was taken by the committee of judges for relaxation of the recommendation of the City Commission in respect to the for issuance of the advertisement dated 21/3/2023, as was done in the previous case.
27
And now also you have done another one. Have you done this also?
But I haven't seen this minute, 2024 minute.
Yes.
Yes.
Because this is done by the administrative committee.
I'll just check the records and I'll place it.
This is the matter on 27/3/2023.
Monday, madam.
This 27,
27
Thursday.
Oh. Can it be on third minute? Can it be on third, 27 already?
You want to come to Kohima? Tell me.
Sorry.
Yes, Mr. Sharma, your matter. Very challenging.
Presently working as an accountant in the establishment of a sixth division, Mr. Dalguri. Earlier, he was appointed as lower division assistant in 1997. With the chief teacher as subject around Mangalore. And after creation of Dalguri sub-division, he was transferred to Dalguri in 1999. And since then, he has been working as a lower division after 2012. In the year 2012, he was promoted to the post of the accountant. And up till now, he's working as accountant post is the equivalent to the part of the assistant.
Wait, Mr. Sharma. What is the name of the person? Oh, 10,000 rupees. How many persons? One, Krishna? The matter of runs to 8 pages, huh? Jayanta Bora. Now, Jayanta Bora is the accountant. Now tell me what is your case?
Accountant is equivalent to the same pay scale, same get, same salary.
Accountant is equivalent to the
Apart is the mistake. So in the year 2023, institution makes a very institution advertisement calling for application for appointment of the post of the head examiner. The petitioner and the respondent number 5 has applied. That after scrutinizing the record, that advertisement was cancelled on the ground that none of the applicant was eligible for appointment as a post of head examiner. Thereafter, again, another advertisement was issued. After relaxing the age of the respondent number 5 from 10 years to 5 years, and the day on which the respondent number 5 has completed 5 years, that advertisement was issued. Because in the age that instead of 10 years, it should be 5 years. And so at that time, petitioner has also applied and the respondent 5 has also applied, but petitioner was not called for interview on the ground that he was not qualified. Okay. But in the other earlier, in the establishment of district judge, accountant was appointed and they had it is annexure 11, page 41. Accountant was appointed. And again, my lord, very interesting. During the penance,
Ananda Brahma. Who is Ananda Brahma? He in the appointed as the head assistant. In the
page 41, annexure 11.
is some city commission again. So earlier there was an accountant who was working in the, who was given promotion to the post of head assistant. There was an accountant earlier who was given the promotion to the head assistant, treating him equivalent to UDA.
Appointed to the accountant. When he was lower division there, he was promoted to accountant to superintendent of administration, 2012. So on the date of advertisement, he has completed more than 10 years of service as accountant with equivalent. So apparently he is qualified. And expenses that there are next 11 para 41. One common man was appointed. Common Upadhyay was appointed. Accountant, he was accountant.
Now, what is the impugn order?
Ordered. Reminder, annexure 12. Oh, no, no.
Who is the respond number 5? Nanda Brahma. That is, I think, annexure 10. Yes,
Page
and
40.
who is working as UDA in the establishment of AI is appointed as the head assistant. He is being promoted. Now you are not being promoted. What is the reason given? Any reason given? Mr. Antas, any reason?
But he was promoted and because seniority, you will also kindly have page 33. This Ananda Brahma, he was senior.
53. Nanda Brahma, he is UDA. Okay, the senior. Then,
Another Brahma, he was not senior. Take copy of that.
It is a judicial list of the employees of judicial magistrate.
68, 87, date of
Okay, okay.
joining as
Who got a
office,
page 40?
UDA 7/8/2018. Ah, yes.
You can go to page 40, my lord.
That's
Page 40
the
and
Mr.
extra
Counsel.
page. If the appointment is
Is a post of accountant equivalent to UDA?
Till now, there is that same problem. But that same problem that we discussed in that particular matter on that day regarding the rules. There is no notification as of now by the government that creating equivalency without all saying that these two posts are equivalent, and that is precisely the stand in the affidavit file. But the problem is that there is another matter in the list today, wherein the Honorable District Judge, the learned District Judge has promoted an accountant to the post of head assistant. As because of non-finalization of the rules, these are happening. I'm extremely sorry for that. And I am also in a state of flux that I am facing this situation.
I never fixed the other matter, those matters.
appointment of the next matter in my slide affidavit, and I heard one, during the tenancy of the case on last, my lord, 2014, the accountant was promoted by the district judge to the post of the head estimator. But both the now the district judge, CGM has filed joint affidavit.
So how does is the post of the accountant, the equivalent means, is a direct recruitment post?
Here, from LDA, the situation is this. LDA, one can be sent to UDA, one can be sent to accountant.
Accountant, one has to be, have the minimum qualification of something is. But the Guwahati High Court rules says something
Yes,
about the
yes.
accountant. You see, Guwahati High Court rules, can you see here, the day I was looking into it. Although we are concerned with the district judiciary, but that is another aspect. But let me see one thing here. Let me see here. Think of the Guwahati High Court rule. Although not the post of accountant, but
Accountant post is not in 87.
so to become an accountant, you have to have some qualification. Now, is the scale of pay the same? Accountant and UDA?
First, my lord, I'll see you under document.
Same.
Page, my lord, my lord, 46. Page, my lord, 46, ARD. The advertisement is issued by the foreigner tribunal, number one. The UDA accountant. Number one, UDA, public accountant.
Page,
Page 46, my lord. Last page of the petition.
UDA triangle, it's the same scale of pay,
46, my lord.
pay.
Number one.
And from LDA, it is a promotional post to accountant and UDA. So,
Yeah, my lord.
So therefore-
Is an exact well, page 44. This matter along with those matter from 27. Because this area is not clear as of now by the government, whether there is equivalency or not, UTA and accountant. But there
but
is,
why are they given the same scale of pay?
it is required.
Huh?
There has to be some decision by the government.
No, till the government does not do it, we exercise 235 and make it.
Yes, that has like in other matters. My lord, in
Because
fact,
here, therefore, in one case, the district judge has done it, in another matter here, the district judge has done it. Now, if you bring him within the ambit of 12, the UDA, then by virtue of section, rule 12(2), isn't it?
comes,
12(2),
Yes.
he becomes senior in the gradation list. Because it will be from the date when you have been appointed as the UDA.
so far as in the facts of the case, who becomes senior, that's a different thing altogether. We get the promotion, but the basic issue that the criteria, that will be settled. Whoever gets the promotion, it's the,
No. I'm saying
in
here,
the, in the.
in the instant case, if he was rejected on the ground of being a accountant and not a UDA, and the UDA post is equivalent to accountant, although rules does not specifically say so, and there is no clarity, but taking into account that it is a promotional post from LDA and LDA, and the scale of pay is exactly the same with UDA. The scale of pay is same.
Yes.
Scale of pay being same. So this has, if we take it as UDA, then by virtue of why I'm saying 12(2), it gives that the seniority will be from the date of joining in the post of the accountant. So he'll be automatically senior. Now the next question out there would be, you are now going to go as per the seniority come merit. Now for seniority come merit, the question will be, you have to have a particular benchmark, which you are going to have. Whether you had the benchmark or barely given it on the basis of seniority, you may have given it because of the fact that normally this 5 years is required to be there in the LDA, UDA. LDA, a person has to be there, and UDA, how many years is required to be head assistant? 5 years.
As per rule, 10 years.
10 years.
I'll just check and
And he had the 10 years.
just relax, my lord. Initially, we issued advertisement for 10 years, then there was no candidate. Then we have.
There was candidate, he was the candidate, na? You were the candidate, first advertisement.
That I was not called for interview.
No, in the first one.
I was not called for interview. Second, when the age of the fire, I got relaxed to 5 years. And that is only issue.
This is the second advertisement. First advertisement,
Cancel, that none of this qualified. Second, your lordship, kindly see the page 44 and exact well. Here is the, my lord. On being selected, Roman Bosumotari, UD assistant accountant. It's promoted to the post of head assistant. And that is my lord. But this matter.
so here the district judge thinks it in a different manner, and the CGM
This-
thinks.
Matter, but before filing the affidavit, but I wanted to have a discussion with the registry also regarding this issue. So that's why there was some delay in filing the affidavit. Some deliberation is required because one aspect will also appreciate that
it has become an luck by chance type thing, you know. Seniority list, he, you know, in 2012, this person got as accountant. Perhaps a post was created. LDA was asked whether you want to go there or you want to go there.
But
So he
obviously,
become-
but it is a seniority post. Means not a seniority post, it's a post of higher scale, which is exactly same with here with the same grade pay.
That's true.
So
The
therefore,
post was
he's not being asked. He's been selected.
I'm sorry, that's true. But the thing is that whether UTA or accountant. So he was selected for the post of accountant. He went there, and the other person, he went to UTA, maybe after several years. But the fact remains that as on date, there is no equivalent. So the learner district judge has followed it in that manner. And
Promoted from the post of LDA. LDA and accountant from LDA. And LDA might be recognized senior, 1997. After completion of 12 years, he was promoted. Which required 10 years, but he has completed 12 years.
bigger post in office, this person, the private respondent, he joined in 87. And the petitioner, he joined in 97.
Suddenly he became 2001.
But he became in 2005. In 5 years, he became accountant.
Yes.
And for being an accountant, I think requires special layer. Because that is what I'm saying here. If you want to be an assistant register account, you have to have a degree in accounts.
Yes.
You don't need to have any other degree, but you have to have a degree in accounts. So something must be there to become a
That's why that I wanted to have some, you know, serious discussion with the registry in these two matters. This is going nowhere. Because one stand in one case.
No, when there is a confusion out there as to whether it is there, so the subordinate judiciary should have asked it.
Yes, correct.
They must have interacted with
Perhaps,
the High
you know,
Court.
perhaps because they were also not aware. Because one is by another district judge, you know, the other thing is by another district judge. So.
So
since
kindly
the
come to
rules were-
here also, page, this is another one, yeah, this is by Udalguri. Okay,
Page-
now that Udalguri district judge does another thing. This is the CGM. Now see the Udalguri district judge doing what at page 41.
Same much. Only same district judge establishment and similar. In district judge establishment, we have a extent 155 years, by the way. This is establishment. But they are 10 years.
No, therefore in the district judge's establishment, it is being done so.
Okay. I have another point also. Well, both the notification appointing Pramod Upadhyay earlier from accountant to head extent and the now present one from accountant to head extent was sent to the registrar general. But they have not raised any objection, no, the district judge or ED extent and accountant are not equivalent. This is the record, my lord.
So given to the register vigilance.
My lord, my reply in affidavit, my lord, page one, for annexure one. Yeah, my lord, the one. From
Sorry, because the other key is also from Udalguri. This
See what I'm
particular
saying.
the other item number nine. So the confusion is I regard to Udalguri itself. But it will not spread.
So what can you do? What best you can do? To go
I
back
take
to
up-
there,
I can take up
you go back to the register general, what best you can do? He can't do anything.
So that's why what I'm saying.
Can he pass an administrative order to revert these people back? Or to consider his case, no?
My lord, the more
He
I
cannot
have,
do it.
I challenge the power of relaxation also. Exercising rule 17, the CGM has exercised relaxation power by reducing case from 10 years to 5. But 17 does not provide such power. Your lordship kind of see that. Note 17.
In fact, Mr. Sharma, I am also of your opinion. Because this is the basic eligibility criteria. The basic eligibility criteria that you have to have 10 years. Can't relax it. Because if you relax it, this goes against the various judgments of the Supreme. I am in agreement with you in this respect also. That day, because of that matter, na, I was a bit surprised how you could have been given there below 5 years. I didn't go into much deep. Because you cannot do it. There are many judgments of the Supreme Court on this point, and there are our High Court also judgments where you cannot relax it. This is the basic idea. What is the only qualification there? Tell me. Only qualification is 5 years.
Condition of eligibility. Residency service, 5 years, 10 years.
This is the basic eligibility.
At the same time, we cannot keep the post vacant also. Like. a
No,
post of
therefore
CAO.
therefore the question is, where is it mentioned that you need, like in the earlier case, in the High Court also, that day I was doing the matter on the Guwahati High Court establishment, register establishment case. There's nothing mentioned about the gradation list of the principal seat or the outstation. You are maintaining recently. In fact, I have noted one of your submission, although you were not there. Another case, Ravindra Burman, there is a submission you made that the gradation list of Guwahati High Court is a very recent phenomena. It only was first done in 2014, and the final was given in 2018. But anyways, where do you have a gradation list in these that you have to have specific to your establishment? Because the 1987 rules does not make it in that manner. It does not say that you have to be specific. Now, this is the big problem which is being faced. You will find it in the 87 rules that it has to be specific to the establishment. No. And more particularly, now you have a centralized recruitment. After Renu, you have started a centralized recruitment. With this centralized recruitment, it is the High Court who posts these people from here to there or whatever may be. And the appointment order is being passed by the district judge on the basis because he is the person who has the power to do so in view of the rules. But every other thing, who will go where a person will go, everything is being done by the High Court under 235. Now the problem arises is the 87 rules does not say that it has to be centric to the establishment.
But the cadres will maintain establishment wise. Each establishment has got an individual cadre.
Each establishment has been made an individual cadre because of the fact that is the
Recruitment.
requirement of that court. And this requirement of the court is not made as the person only at the behest of the district judge. The district judge requests for creation of the post, which is being placed before the High Court. The High Court, the Chief Justice have to approve to that effect, and on the basis of the approval, the matter is placed before the court, before the finance or all the state government. Now the state government thereupon creates the post and places it again to that particular district.
And district judge is the appointing authority.
They are the appointing authority, but this is only for the post, but not for the person. What is being done is they are making it person-centric. That I am appointed here, I will have my seniority here. Where is it that I find there's nothing out there to that effect that it is only centric to this? Then how do you see on the administrative side, we find out that this person is going from here to here. This is a convenience. Can you be said that he is only the post, he only has he enjoys a lien in respect to the post at Kamrup Metro? No. His lien is only to that post of an LDA. The rules of the Rule 12 does not say anything about LDA in this establishment or that establishment. I don't think so. And more particularly in view of Renu, it may have become more difficult because what is being happening, 87 is one by which obviously the district judge can very well do so. The district, because they have mentioned is district establishment. The district judge establishment will take it. That is one thing. He will take it up. But after bringing in Renu and having a centralized, how do you gel both together? Very difficult.
So that's why, my lord, the draft rule that is, my lord, in the pipeline, that particular rule was been, in terms of revenue. So it takes care of that situation also. What will happen in the matter of central, in that earlier, that matter, my lord, centralized recruitment was done, my lord. Then the district judge given appointment different dates. Now, if we follow June 12, then appointment order, then it's almost a situation.
Look,
of
there is
that.
another case. That day, one case where you were not there, I put you
I
as a respondent.
I-
Now, what has happened in that case, which is, I think, maybe coming up on 27th or 28th, this case has a very important aspect. Here, the High Court, in exercise of its power, directed the MACT member that kindly issue the appointment letter.
Exactly.
Now, what he does, he issues the appointment order to number 2 and not to number 1. And number 1 he issues subsequently. Now, although 12 says date of the appointment of the order, from there the seniority will be counted. But the fact that here the member was bound under 235 to hear and appoint in as per the seniority. Now, it is the fault of the member in issuing. So, what is required to be done in that case is that you have to read this particular document which have been issued subsequently as being issued previously.
And the
That
learned
is how
member-
you have to
the
deal.
learned member not have issued an order. Because here, although the learned member had issued the appointment order on 2 different dates, but per se those will not be appointment order. The appointment order would be the order issued by the Guwahati High Court.
No. That would not be. It will be the member who will have to appoint because the High Court does not appoint him. High Court says that these are provisionally selected and as such you are to issue the appointment order. Now, these are the 4 names which have been given to appoint. Now, what he does, he appoints the number 2 first and number 1 second, which is wrong. So, this is on the point what can be done is that the number 2, this particular appointment letter has to be read as being issued prior to that. This is how justice can be done in that.
Exactly.
Otherwise, rule 12.1 makes it very clear from the date of the appointment, and there's no, and the use of the language out there categorically say that if a person joins within 15 days, he gets from the date of the appointment, and another 15 days is being given. Now, after 15 days is given, if it is not, the question of extension further does not arise. So it has to be as per the rule that it has to go back again from the date of the appointment order. Now, this is the only where therefore you have to read. You cannot, otherwise it will conflict with 12.1. So you have to read out here to make it that it has to be deemed that it has been issued prior to it. Therefore, you see that my other judgment in the UDA matter, I have put their appointment from the date of these people's appointment.
Yes, sir.
So that, and they are being given notionally to that effect from that date, because otherwise, and it will be deemed that they have joined. Otherwise, later on again, the 15 days will come in.
Yes.
So that is how it has been given in that case. Now here, in this case also, the problem which arises, something is to be done. We have to come to the effect that it is accountant, it has been done. Now, how will the Registrar General help you? I'm coming in 10 minutes, think.
Yes, sir.
Otherwise, why should I?
Perhaps
not to
subject to what your lordships, considers, the exercise that has been done like public typing and computer typing, perhaps that kind of exercise will be required here also. That is my
Yeah, where is the government? Government.
government,
The
mainly
government is a party here.
government is the,
You not made the government of a judicial department. They are the people who issue the notice.
yes, respondent number 1.
It is there. Reform number
Their
one is there.
main duty is there.
So get hold of the government. And
Yes.
I'm coming
I'll
with
ask them.
them.
Petition is not included in
Let us come up with that. If we can get some clarification from that end. Let us see from this.
Yes.
Calling from eligible employees of the establishment of the Chief Judicial Magistrate Assam and making it specific for filling up of the vacant post of the office of the Chief Judicial Magistrate Udalguri. So then, how does the question arise that you are only restricted for the people from Assam, only from Udalguri?
Yes. That referendum is below nine. After calling from all over Assam, we were not able to fill up.
Whether it is,
So that's
how
why-
many people have applied?
So in the previous one, when we picked the criteria 10 years, even then calling from all over Assam, we did not get candidates.
Because they must have been under the misconception. That is why he is coming out here to say that look here, I am I'm number 3 out there. They have put me in the wrong gradation list as number 3. But otherwise, I should be as I am the accountant as on 17/3/2012, which is equivalent to the post of the UGA. So therefore, I'm senior. So he is coming under 12/2. But you are calling for the post from all over Assam.
Here below 6, the rule will be below 6, 1 of this.
No, I'm saying about seniority. Seniority will be 12/2. See 12/2. Isn't it?
The lower division cadre the signature according to the date of appointment with the person joins the appointment. Yes, the earlier one.
So therefore, his seniority he is claiming from 2012 on the basis thereof.
Yes.
That he has 10 years of service, whereas the other person does not. This is his case, he's made up. But the question is whether there is an equation of the post of the accountant with that of the UDA. That is one. But now in the advertisement also you make it clear that you are calling from everyone. Now does the 87 rule say that the seniority, maybe there might be a gradation list for everybody, maybe for the purpose of convenience. But is it establishment centric? As per 12, rule 12? I
It is
don't think. Here you see head assistant and solicitor of additional and district judge by selection amongst the persons who have served as supervisory assistant or solicitor of the municipality or solicitor of the Assam district and session judge or upper division assistant continuously for 3 years in the district judge's establishment. Now the only bifurcation from the district judge's establishment or the chief judicial magistrate's establishment is by Rule 17, whereby the establishment of the special judge is outside the purview. Where the government we are also allowed to appear in person, not appearing. Because you see, as the issue involved is at finally see Rule 18 of district judge.
If any question arises, that Rocky was referring to that. If any question arises relating to interpretation of this rule, shall be referred to the government in the judicial department, whose decision thereon shall be final.
So it is not for the High Court to decide as to whether the accountant will be UG or not.
Clearancy may not solely lie with the government. Our powers are restricted to some extent. The power of transfer and posting of staff from one district to another district rests with the government.
Now, this rule seems to be in conflict with Renu's
Power of transfer.
In fact, this is not only conflict with Renu. Renu came later on. Earlier judgment of 1967 Constitution Bench. They say that you cannot. Power under 235 very beautifully written out there in the 67 judgment. Yes, but they don't have the power to do that because the moment you do that, it will have a function also.
Infringement.
Mr. Senior Government Advocate, the problem has arisen in this matter because of the fact that the rules have not been fixed. We will consider that on another date. But the immediate problem here is the post of the accountant in the district judge's establishment is a promotional post from the post of LD. The salary of an accountant and of the UBA is one and the same. Same grade pay, everything. Now, in this case, the petitioner herein was appointed as an accountant in 2012. The respondent number 5 was appointed as an UDA in 2018. Now, in the year 2023, a selection was held. Although for the purpose of becoming a head assistant, you required 10 years as an UDA. But it was relaxed and the response number 5 was appointed. Whereas, if it is the petitioner is the concern, the petitioner should have got it. Because he had that if it is considered to be UDA.
It's simple.
Now, what has happened? Another thing is, in other establishments, or even in the this is the case of a chief judicial magistrate establishment of Udalguri. The district judge establishment of Udalguri considers the post of the accountant to be equivalent to UDA, and accordingly promotions have been given. Many other cases also where an accountant has been given the promotion to the post of head assistant, treating it as an UDA. Now, although in the draft rules, the accountant has been put in the same stature of an UDA, but there is no similar notification like that 16/9/2024 notification by which LDA piece everything has been brought within the framework of LDA. For that. So the question arises out here, taking into account Rule 18. What is your interpretation on whether the post of the accountant would be that of the UDA or not? You need to file an affidavit. It is a promotional post. There are many posts. Just for example, you have a file, you have the reputation. Kindly see the reputation out here. Kindly see this. Kindly come to page 46. This is a advertisement issued by the member Foreigners Tribunal. Okay. There they have put the post of UDA and accountant at similarly. Public. Okay. Then you'll see here at page 44. This Roman Musari, who is UD assistant, accountant, is posted to the post of Solicitor Dar, additional district judge, because he has been treated to be an UDA. Then you see, this is the same thing which has been done at page 41. Another person, Kamal Upadhyay, working as accountant, is being posted to the establishment as well, so and so of the
District judge.
head estate. So he's being treated as an UDA. Now the rules have not, the new rules although say so to that effect. Isn't it, Mr. Das? The new rules have said that the post of HDA, UDA and accountant are the same. Isn't it? Now, if that be so, you don't have also any objection to that aspect in your letter. I remember when I was taking up that matter, it was categorically said that the post of the accountant should have been inserted out there. If you remember that day, Mr. Iya was saying on that particular, the letter which was issued by the judicial department and requesting the High Court to amend this rule or putting the category, the schedule out there, that the post of accountant has to be inserted because that was a post which was created. And the new rules also mandate to the same. Now, whatever may be, now this court can very well, they decide to their effect that the post of the UDA is equivalent to accountant, taking into account that the High Court is overall in charge under 235. And more particularly, Renu and other judgments out there. So it is the High Court who is actually the employer. But the payment is being made by you. It's a different thing. So that can be done. There's no quarrel with it. But the only thing is, as a judicial department, if you are there, we will require an affidavit as regards the post of account, which I think may come up in favor that it is equivalent to UBA, taking into account that is your specific stand in that other cases. And I think with that, things will move in the proper direction. So we have it on 24th of April. Okay. 24th of April. In the meantime, you need to file your affidavit as regards the equation. Now, in that judgment of, there are two judgments. One is one Mamata Chakraborty, where the Supreme Court said about equation in the High Court was said so. Now, the High Court said in the case of Shyamal Saikia also, as regards the equation, the owner, the employer knows it. Now, in view of Article 235, the employer actually is the High Court, because any other interference with there would have an impact. Just for example, Rule 19. Rule 19 runs contrary to the Supreme Court judgment that you don't have a right of transfer. The transfer is still with the High Court, because otherwise it will have an impact on the running of the independence of the judiciary.
If not, look, they have to clarify it.
Just a clarification by which it is done, because there are not one. There's another matter, na? Item 9. Who is there in item number 9? You are there. So there also, here you are challenging the appointment on the ground that he was an accountant, not a UDA. His case is this. And this case is he is the accountant, he is a UDA.
He has not been given seniority. Seniority has not been given. Seniority benefit has not been given. Otherwise, he ought to have been promoted to the post of head assistant.
No. His question is that look here, they have given the accountant. Accountant does not fit into the role. He's not an UDA. And a UDA can only become a head assistant. That is visible. Item number 1292. The issue involved in both the repetitions is what is the status of the post of the accountant created in the establishment of the district and session judge. In the establishment of the district and session judge and the chief judge judicial magistrates courts. Whether the post of the accountant can be equated with the post of the upper division assistant, or it is a separate post altogether. This difficulty has arisen in view of the fact that when the rules were made view of the fact that in the Assam district and session judges establishment ministerial service rules 1987, the post of the accountant is not there. For the districts of Udalguri, Sirang, and Baksa, only on 4th of November 2015, these 3 posts of accountants were created. Taking into account that the posts were created by the government of Assam. And their stand is required to be known prior to passing any judgment in both the petitions. This court fixes this matter on 24th of April 2025. The Commissioner and Secretary to the Government of Assam Judicial Department, who is the respondent of Judicial Department, is directed to bring on record the stand of the Government of Assam in respect to the said issue by filing an affidavit on or before 22nd of April 2025. Mr. Deenath, the learned senior government advocate, submits that appropriate stand would be brought on record by filing an affidavit list accordingly. On 24th of April 2025 for further use. 9 also. 9, both again also. Okay.
Item 5.
Yes, what is this? These high court matters, these have a lot of unnecessary complications. If it was a matter of the other matter, it is much clearer, easier. Easier means high court rules or all these things. Yes, what is your case?
The better compassionate appointment, Lordship.
What compassion? How many years? What is your age?
My father expired on 9/6/2016, Lordship.
Then?
Then my mother applied on 2018, Lordship. It was rejected, Lordship, because there's no vacancy. But while rejecting, it was said that when vacancy arises, you may apply again. Thereafter, since my mother is of any health concern, I applied. My application was rejected on the ground that there are only 17 posts of grade 4 in that establishment. So 5% is the, as per the scheme, it's the 5% is the vacancy hotel select has to be appointed in this professional appointment also. So it doesn't come to what, so rejected also. Whereas also, if we calculate it, it comes to 0.89 and as per Supreme Court.
What are you doing? What are you doing?
And I'm unemployed also.
Yes, that is why you are before the court. But what are you doing? What is your age?
My age also, I have completed my MA also. I have completed my MA.
And what do you want? Grade 4?
Grade 4 also, because there is no way Lordship out.
Huh?
There's no way.
MA in what?
Trying, also, but there's
What
no
is
way
your
out, Lordship,
MA in?
because
You have done your MA in which subject?
English, Lordship.
My goodness, what are you going to do? You cannot get a grade 4. Try your luck somewhere else.
Because Lordship, because during my father's treatment, we had taken so many loans from the personal vendors also, we have to pay them, we have been paying them from whatever family pension we have been getting, Lordship. Somehow we are surviving, my mother is in ailing, Lordship.
Your father died in 2016.
Still, Lordship. Moreover, during the COVID period, so Lordship. That's why, Lordship, I had made my application in 2022, Lordship. After COVID was over, Lordship, and then it was rejected.
How did you complete MA?
Lordship, I have annexed my. September 21, Lordship.
September 21. That? And what is your policy for compassionate appointment?
The scheme is that is 39 after repeat.
Scheme for the post of Guwahati High Court Principal Seat and District Court of Assam.
Kindly save it clause number 17, my lord. At page 42.
When did you die? I mean, so what was the age of your father?
Somewhere 57 probably was it.
What is the retirement age?
It was 55 was it. At the
Huh?
time of the- Just 1 minute.
Huh?
Fifty-four years was at the time of it.
How many years he had?
And he had given 29 years of service, 50 years, another 6 years. was-
Your father was working as
My father was working as a lordship.
lower
Lower
division
division
assistant
assistant.
in the post of chief minister before his expiry on his appointment was of the 1890. Was at the time. Your name is what?
Sikha Dr. Lordship. I am the eldest Dr. Lordship. I have two more younger sister and a brother. One more younger sister and a brother.
Year 27.
Yes, Lordship.
Why is it rejected?
The order is at page 59, Lordship. May I read, Lordship? At the last paragraph. Lordship. Further, as per your report, dated 31/8/2023, 5% of the sanctions strength of the in grade 4 together is 17 post in your establishment. In your establishment to be filled up on compassionate ground comes to less than one post. And as such, none can be filled on compassionate ground also.
Yes. Mr. Bush.
Hello. Whether there is really a direction from the part of the petitioner.
There is no delay. Mother had filed it immediately thereafter in 2022, no?
And 18 months.
Filed it. Again, the daughter has filed it
It
in
was
2000.
decided on 12th, sector 10.
Now you see, you are saying that 5% of the post. Yep. Establishment of the CDM. 29. So that is one post that has already been filled up.
And for grade four, total 17 posts and 5% of 17 is not one. And it cannot be rounded up.
Understood. Now tell me, is it necessary that it has to be only from that Dhemaji? It's only necessary that it should be Dhemaji. You have put your scheme as principal seat. Where is it mentioned that it has to be from that establishment?
In fact,
Because the applicant applied before the CGM Dhemaji.
Understood, but CDM is only the go through.
And CGM forwarded the
You have taken the decision. So why are you limiting yourself? Because here you don't see it in the permanent staff of the Guwahati High Court at Guwahati and district establishment of Assam. Here what you are going to keep is that compassionate appointment is not a mode of recruitment. There's no quarrel with that.
Yes.
Now you have a scheme out here that look here we are going to appoint. It is not centric to that establishment. It is centric to the establishment. It is
in
the
every,
scheme.
in every establishment. There are applicants of compassionate appointment.
Maybe.
And they are competing within themselves. And
Why you are making it within themselves?
on that particular establishment.
No. Show me from your notification that you can do that.
On that, let me take.
Again, the same, let me
Fine,
take
in
this.
fact, Lordship, if I may
My
take your
lord.
Lordship to one rule of the scheme, Lordship. At page 43, Lordship. It specifically says in smaller cadres, where number of posts is less than 10, two or more similar cadres may be clubbed together to get one post for compassionate appointment.
Where number?
Page 43, clause B, Lordship, it's 17B.
Smaller cadres where the number of posts is less than 10, two or more cadres, similar cadres may be clubbed together to get one post.
Meaning level, Lordship, if number of posts is 10, Lordship, it comes to 0.5 and below, Lordship.
Can be a maximum of 5% of the total strength of cadre at the time of recruitment in any grade 3, not above the cadre of grade 3. For grade 4, while calculating maximum recruitment, total number of posts already occupied by person appointed on compassionate cadre in a particular year of recruitment shall be taken into account. If the number, what is this cadre business? Cadre will be this cadre only. The cadre of LDA and the cadre of so and so. Isn't it?
Grade 3 and grade 4.
It will be that cadre only. It does not say about a particular establishment. Does it say so? If the number of such persons already constitutes 5% of more than the cadre strength, no new appointment shall be made to that cadre on compassionate ground. If, however, the number of persons is less than 5% limit, appointment may be made in such a way that together with the existing appointees on compassionate ground, the total strength does not exceed the specified limit of 5%. So this is more like a centralized one.
Unless on that,
What on that?
let me take instruction.
Yeah, every
And
time Guwahati High Court, whenever matter comes, I take instruction.
My developed theory is also there.
So what? Development theory says that it is not so. You should not give it. You have not changed this. Then why you are still having this type of year? The Guwahati, the state of Assam has already
Already
changed
done
it.
it.
They've always
Okay,
changed it.
18,
Why
19,
you are not doing it?
And can you consider one thing, my lord? We have filed in our affidavit.
You file your affidavit, no, you file an affidavit as to the total establishment of the principal seat as well as in the subordinate judiciary of Assam, in the district court establishments of Assam, how many posts, what is, and how many posts are vacant on account of compassion? If that is being brought in, we first have to go to- we are not concerned to as regards establishment. He may be tomorrow you may put him to Baksa. If she wants to go to Baksa, let her go to the Baksa, or she will put her to Kokrajar or Karimganj, or even the furthest town is Karimganj. Karimganj. She's willing to go to Karimganj. Therefore, the instant petition has been filed by the petitioner challenging the communication by which communication dated 29/2023 by which the petitioner's application seeking compassionate appointment was rejected. The legal counsel appearing on behalf of the petitioner had submitted that the basis on which the application was rejected was arbitrary and not in consonance with the scheme for compassionate appointment for Guwahati High Court principal seat and the district court establishment of Assam, notified by notification dated 3/1/2017. The learned counsel further drew the attention of this court to clause 17 of the said scheme and submitted that a cadre mentioned therein is the LDA bracket direct recruitment or the grade 4 direct recruitment. The learned counsel further submitted that by the impugned communication, the rejection which have been made is being made taking into account the establishment of the Chief Judicial Magistrate Dhemaji. He therefore submitted that the impugned order requires to be interfered with and appropriate direction be issued for fresh consideration of the application filed by the petitioner. This court inquired with Mr. G. Bashir, the learned standing counsel of the Guwahati High Court, as to why in the impugned order dated 29/2023, it has been made in connection with it has been made it has been made on the basis of the establishment of the Chief Judicial Magistrate Dhemaji centric and not the post of direct recruit, the post of LDA, direct recruitment or grade 4 direct recruitment, which is the cadre mentioned in clause 16, 17 of the scheme. The learned counsel for the Guwahati High Court submits that he will take instructions. This court directs the Guwahati High Court to file an affidavit giving details as to how many posts are vacant on account of compassionate vacate. In the cadre of LDA direct recruitment or grade 4 direct recruitment. In the principal seat, as well as in the entire district establishments of the government of the district establishments of Assam, which can be filled up by way of compassionate appointment in terms with clause 17 of the scheme. The same details be furnished before this court by filing an affidavit by 22nd of April 2025. To list this matter on 24th of April 2025 for further question. I can only, once I get there, I can only ask them to consider in terms of death, nothing more. That is the final relief you can get. Yes, of course.
Public. Item 7.
Yes, what is this?
This is regarding the selection and appointment of Jari Karappan in the establishment of district in Jaswantpur.
No problem with the,
Well,
no problem with the rules, no?
no.
That's I'm thinking, if the government keeps on putting out there, we have to pass on. They don't do it. But the institution can't wait, keep on waiting like this. Huh?
Give the reasonable opportunity. You do it. If you don't do it, then we.
That is what, because the thing is, if we don't do it, you see, if it is any other department of the government of Assam, I'm telling you, either they would have come with some administrative executive instructions and would have filled up with that. But here, they don't into a lot of difficulties. Therefore, I use the word their stand. I'm not saying what they want to say. Yes, what is this?
Here, perhaps, I have to file an affidavit. I have received the instruction. The issue is with regard to your, they have said that when the respondent, he has been.
You want to file affidavit, you have not filed.
I have received the instructions, sometime.
You have it on 24th.
24th of April. Fine,
You file your affidavit by 10th of April.
fine, madam.
They file their reply by then.
Fine.
It has been, who appears for the response number 5?
From name,
You file, have you filed your affidavit? Why?
I am being approved by you.
So you don't have anything, you just want to file for the sake of it. It is seen, Mr. H.K. Das, the Learned Standing Council of the Guwahati High Court submits that he has received the instruction, then he will be filing the affidavit. Mr. S. Das, the Learned Council appearing on behalf of the respondent number 5 also submitted that he will file the affidavit. It is seen that the direction to file the affidavit was given on 27/8/2024. And we have already, we are nearing 6 months and no affidavit has been filed. Considering the above, this court grants a last chance to both the Guwahati, to the respondents to bring on record their affidavit by 10th of April 2025. Upon filing of the said affidavit, if the petitioner if so advised, to be at liberty to file their affidavit in reply by 22nd of April 2025. List the matter again on 24th. Further consideration.
Deeply.
Yes, what is this?
The petitioner was re-employed.
Finance department has not filed.
His remuneration has not been paid.
Who has filed 4 and 5 is you.
Yes.
What is your case?
My case is that he retired as assistant registrar Guwahati High Court.
Hmm.
Thereafter, he was re-employed.
Ah,
And for 1 year, he worked from
Ah.
2021 to 22.
Ah.
But his remuneration has not been paid.
oh,
Now, then this affidavit has been filed.
Five?
We have a 4 and 5, where they state, that is the High Court. High
Ah.
Court has stated in the affidavit that the sanction has not been received from the government.
without the sanction they have appointed. You have re-engaged.
As far as I have received legal remembrance. There is a no sanction lodged.
Huh?
Without sanction lodged, he is going to.
Who is appealing for the High Court? Oh, this matter. Chalo. Oh, wait, this I can't show you. Why do you give request for adjournment? I was about to issue rule in this matter. Admit and fix it for hearing in the usual courts. You know that? Well, luckily I didn't do. Other 2 matters I've already done it. Be careful, Mr. Bhattacharya. Don't read request when they ask for adjournment. Isn't this a matter of urgency?
Yes, sir.
Then
So
What
they
is
said
it
that
when
they
I
have
don't know?
some difficulty today.
difficulty, no difficulty, let the matter when the matter is taken up. This will be appearing. Otherwise, this court would have passed that order. Okay, why haven't you filed your affidavit? And madam, why should I? Oh, no, he has filed the affidavit. Why you have not filed your affidavit? We will not consider, I made it clear, do not file the affidavit. This court shall proceed by applying the doctrine of non-traverse. We will say that there is a sanction. You have not filed the affidavit.
Yes, sir, that.
You have filed the affidavit.
I have. But I
Cost 10,000. I cannot. Finance has also not filed. Finance does not want to file. It's okay. Because I passed the order. It is observed if the respondent authorities who have not filed the affidavit do not file the affidavit on or before the next day, this court shall proceed by applying the doctrine of non-traverse.
Yes,
So we will not consider that there is a sanction.
that,
We will consider that the government, the High Court had appointed, asking him to make the payment.
the instruction.
I'm not.
That-
Instructions, no, because instructions is not on affidavit. Tomorrow, anybody may say anything. Instruction is not on affidavit, so we'll go by the doctrine of non-traverse.
Actually,
No.
whatever was the instruction
No,
from the
nothing
Guwahati
doing.
High Court, the LR has not received the information was from the Guwahati High Court. That's why was delayed.
What?
That's why instruction was delayed. They have
What? So first of all, finance has not filed it. Finance cannot say no. Finance has not filed it. So the question is this, and
but he has to.
but I will only permit subject to 10,000 cost. Otherwise, no. I'm very particular on this. 10,000 is the cost. On 10,000 from you and 10,000. This 10,000 should go to you. So you have not received any salary. Not to legal services authority. Bank account, provide. No problem.
May speak, my lord. Here, my lord, we have filed consolidated affidavit number. And and my query is, my lord, the read petition 2755 may be taken up first.
The feeder post to the post of court officer is AOJ and HA. That it is okay.
Class 2B, 2C, and 2D,
No. Feeder post,
including stenographer.
feeder post of the post of court officer is the post of AOJ.
Yes.
So an AOJ can become a court officer. And an HA can also become a court officer. Now, if HA becomes a court officer, you have a selection proceedings because you are making him from T to T. How do you do it?
My lord, that is
Not there.
not in the book, my lord. That is Rule 7. My lord, kindly consider the history. Prior to 2015, the post of court officer was established. In the year 2015, it was encated. And my lord, principalship, there are two posts, and then my lord, provision
Are you saying, are you saying that when an AOJ becomes a court officer, he is of the equivalent rank? Because his scale of pay remains the same. Yes. He, what she doing?
AOJ is level 8 officer.
However, maybe an AOJ can become a court officer.
That is it.
So when an AOJ becomes a court officer, so he goes to a parallel rank or is he demoted? Tell me.
As per this notification. In 7 they are maintaining their seniority in their respective grades.
They are maintaining it okay. So what is the effect of an AOJ becoming a court officer? Is it demoted? Because the feeder posts are two. One is HA and AOJ.
Sound itu itu ना audible mang
लाओ गायब कर दिया
Mr. Pangin?
My
Can you
lord,
hear
there's
me?
some, yes, now there's some difficulty with the connection here.
Okay, can you hear me now?
Yes, my lord.
You see, the post of AOJ
my lord.
and SJ,
SJ,
that is Senior Judicial Assistant,
yes, yes,
are feeder post to the post of court officer
yes,
as per even the 2015 notification.
yes,
So my question to the High Court Counsel is
yeah,
whether an AOJ is demoted if he becomes a court officer.
exactly, my lord.
And if he is not demoted to
My
that
lord.
post,
Yes,
can you say that a post from the SJ person goes to the court officer and he is not promoted?
exactly, my lord.
How do you harmonize? You wanted to harmonize both.
I'll do that.
How do you harmonize?
My lord, my lord, kindly consider one thing. The very contention of the petitioner, that's their the promotional criteria is seniority come merit, is wrong. Merit comes.
I'm not on that.
My lord,
No, I am not on that.
when it
No,
is
no,
merit
no,
comes
no, no,
merit.
no, no, Mr. Counsel.
My lord,
Let it be merit come seniority, seniority come merit, whatever may be. The question is, he comes within the zone of consideration. The petitioner wants to come within the zone of consideration. He is not asking for promotion.
Yes,
His only question is that he should come within the zone of consideration, which you are saying that he cannot come in view of this notification. Whereas you have not amended Rule 7.3.
yes, exactly, my lord.
Without amending Rule 7.3, can you say because of 7.4 or 7.4A,
Recorded.
a person concerned who is promoted? This is the only thing. The logical
Yes,
conclusion is either the AOJ has to be demoted or this person has to be promoted. You don't agree because a person cannot be demoted. And unless it is a punishment. So he cannot be demoted. So he has to be promoted. So this SJ is being promoted to the post of court officer. Now, once he is being promoted to the post of officer, 7.3 says that he can become a feeder post, the post of assistant registrar. Whether he is selected on the ground of merit come seniority or seniority come merit is not the issue before this court.
yes,
The only issue is as to whether he will come within the zone of consideration to be taken into consideration. That is the issue. Let us not confuse ourselves on that.
my lord,
exactly, my lord.
to that query, my lord, kindly consider 7.3 and 7.4. 7.4 was came into force on 24/7/2015. Prior to that, the court officer was a escalator. Madam, there the petitioner's right accrue to be promoted to the court officer by this notification. And prior to this notification, 7.3 was there. 7.3 was there for whom, madam? Kindly come to the city.
2C.
2B plus 2C and class 2. My lord, kindly come to class 2C. Who, i- who, is- who is the person? The person number one, administrative officer. They were there prior to encountering the court officer. That's why 7.3 is there. 7.3 2C says that it means that.
But are you saying that your insertion of that schedule is wrong?
No.
Then
No,
how did you encourage it? The moment you have encouraged it, you should have thought about it. This is the problem. You couldn't have done it. You should have put him under 2D or whatever may be, but you can't. The moment you are bringing the AOJ equivalent to him, that is the big problem which you have done. Your rule 7.4 or 7.4A is wrong for that purpose. You should have only put it a person can become from SJ. Why did you bring the AOJ from there? The moment you are bringing the AOJ, he is giving an equivalent post. A person, an SJ, after an SJ, a person normally becomes a court master. That is 3. From a court master, a person may be promoted to the post of AOJ, court officer, or anything. Court master also from a court because he is 3A. He's non-gazetted. But you are making him a gazetted.
Courtmaster, 2D.
Huh? 2DD is court master.
Yes.
You see, here you see his salary. This 2DD court master. Now, from AJ, one can become a court master or an APO.
Yes, ma'am.
Okay. This is a promotional post. Now, from SJ, one directly becomes a court officer on AOJ. And from SJ, a person become an AO.
That I have to.
No, there's no. Today you are not escaping that I'll take instructions. No. Hey, where's that gradation list that day I saw somewhere? I asked these people to place me. That day, yet, I should know, I should know what activity. Oh, yes. Got it. Yes. Now you see, let us take the case of his petitioner. His name is one Mr. Jahirul Islam. Okay. Now he becomes SJA. What is SAA? Senior. SAA. A judicialist. Okay. Now he becomes, kindly see the gradation list here of Mr. Islam, who is the petitioner. He becomes SAA on 30/10/2016. 13. As per the gradation list. Now, all these other people, these are AOJ. These are court masters. Now he becomes a court officer on 18/4/2016.
Yes.
Okay. Now, in this gradation list, which is being prepared, his gradation list is being prepared exactly as per the seniority maintained in the SAA. Isn't it? Now, from here, he becomes the court officer, which is equivalent to the question of AOJ. Now, these people have been promoted as AOJ recently. These, all these other people, well, I know one of them happened to be one of my court officer. What is this person's name on Zoom? Here it is being mentioned that his seniority is maintained as per this SJ. Now, he becomes a court officer on 18/4/2016. 16. Yes, from here. which means the people who were otherwise senior to him in the SJ category have recently become an AOG. Recently. Huh? 1 year. Now, there are some people who have become AOJ recently of these who are senior to him. Have become an AOJ recently, but he has become a court officer from 2016. This person concerned. Now, rightly or wrongly, what you have done is, I won't say that. But the question is, the moment you are bringing him into the post of court officer, you are giving him a promotion to the post of court officer. Normally, the post of court officer or any AOJ post or anything from the post of court master is a promotional post, isn't it? Three A, from 3A, a person goes to 2DD, then 2CC is deleted and 2C comes in. Yes. No, that chart is wrong. That chart you have prepared it without looking into on the basis of 4A. That chart puts a direction that from here, a court officer, he will go to become a AOJ and from there it is there. But when you are bringing the post of court officer within the ambit of 2C, there the problem arises. Can't help it. Now these people who are much senior to the petitioner, just for example, this Nomita Rabha, Manoj Kumar Goswami and they have been recently become AOJ on 10/1/2025. But this person concerned became a AR on 2016. So the problem has been created by you. You cannot say that no, nothing will. You will have to get it in view of 3. What do you say, Mr. Panging?
Audible.
What do you say? The moment without amending Rule 7(3), they
Madam.
cannot take away the right of him to be considered for promotion. You may get or not, that's a different thing. I'm not on that. But whether he will come within the zone of consideration is the question. He will, taking into account that in that 7(3) has not been amended.
On that, some judgment on harmonious master. How it has to be interpreted. The earlier system, the later system. The later system cannot be negated. On that, I will put it before that, my lord, kindly my lord, ask some regarding the proportion of these 3 categories, class 2A, 2C and 2B. On that one, there is one committee.
No, that will be this court holding the 2C, 273, where it puts 2C is wrong. I have to hold it. Can I hold it? that 2C could not have been brought within or to have been amended or could not have 2C could not have been brought within 7.3. Can I hold it? Tell me? Whatever harmonious or literal or whatever construction I do, can I do that?
On that, my lord, my prayer will be this, my lord. 7.3 and 7.4 will be considered together.
You want to read down 7.3 to say that in view of 7.4 now, 7.3 remove 2C. The court officer, post of court officer.
Not removing. Because we are by that notification of 2015, we are giving them opportunity to promote it for the post of court officer.
So you
They are-
therefore,
they are-
you
they are
therefore
Right,
admit,
created by that notice.
so therefore you admit that it is a post created for promotion. The moment it is a post for created for promotion from SJ, next post is he comes within 2C. Who has brought the post of court officer within 2C?
My lord, to see their promotional order and the rule says that, my lord,
No, show me
Rules
how
says that.
a post of court officer was brought within 2C. The only way out for you is to say that 2C, the post of court officer was never brought within 2C. That's the only way. Can you say that? You cannot say how it was brought within 2C is your main consideration. Otherwise, you make it. No harmonious
rule
construct.
7.4 says that, my lord, the post of court officer in the principal seat of the Guwahati High Court and the Kohima bench shall be filled up by calling options from the administrative officer and the senior judicial assistant. The person so appointed in the post of court officers shall maintain their respective seniority in their original category. Shall maintain their respective seniority in their original cadres, that is the cadre of administrative officer judicial and senior judicial assistant, SJ, that is SJ, and their further promotion will be considered on that basis. Now, my lord, on basis of that, the petitioner, Zahirul Islam was promoted. Thereafter, in 2018, he filed a reprisal. That is not the part of the record of the reprisal. That representation was dismissed. And my lord, he filed this case in 2024. And and
Mr. Bosso, I think we have traveled the lot to say to go on this technical objection.
my lord, I have to apprise your lordship regarding the fact.
Facts is okay. Kindly don't come up with those technical objections. The question is whether he will come within the zone of consideration without amending 7.3. Only way out, I'm giving you that way. The only way out is you have to say that the post of court officer was never brought within 2C. Mr. M.K. Chaudhary's book is wrong. But the moment you say that it comes under 2C, there's no way out. Yes, what do you want to say? Yes. Okay, tell me what you have to say.
Well, I doubt that we have want to read petition properly.
Okay,
At
tell
the
me
age of
otherwise.
I
Without the
don't
brief
know
also
that-
say, I am not opening up the brief, I am therefore see from the rules. How do you interpret 7.3?
Minister should be appointed from among the state judicial service GP, or by promotion among the gazetted officers of the High Court service belonging to class two. Or from among the. Right.
How do you interpret 7(3) and say that 2C, although includes court officer, these people are excluded?
News can that I just would try to go through the rules and I'm prepared of this.
You have filed an IA?
I filed and it was allowed my name.
Why did you file an IA?
No, but it was allowed.
Then very well, argue.
No, but the mostly things that looked at my name, I don't even have to have not done a single word through it. Even a day's time I'll come back
Why did you file an IA?
to be impeded because
Why? For whom are you?
my lord, for the persons who are senior to this to the commissioner, say that prior to him, if we come into the zone of consideration, he gets some.
Huh?
We will be in the zone of consideration. Only he does not. We remain in the zone of consideration. Above him in senior. Therefore, our opinion was allowed. So that we can resist the repetition that cannot be limited to him or perhaps to the extent that he will not be applicable. He will not be the person who is going to the zone of consideration.
Why?
It's us we come.
So you will come because of the same post. How many posts of esteemed ministers are being put? How many posts? Advertisement?
Actually, that was one person.
So it will come with 5. 1:5.
We are 11 people at least above him. From 4 to 15 we have been included, so we are at least 11 people above him. He would not come in the zone of concession. This may not require a decision on what he is asking for as of now. Because he will be superseding us, everybody with the court order, which he did on the last time he was promoted. That happened. There was a court order, he was considered, he was promoted. Surpassing us all. This is the second time it is before this court.
No,
Therefore,
it's okay. No, the question is for you. It is not that the 2C person would not come in.
yes.
The best interpretation which can be given is that person concerned 2C would not come in. But he will, all these persons has to be considered in the terms with the seniority as far as A.
Totally at a loss. I am not being able to relate the file with you. I just heard the name. I heard a few words. I thought perhaps this is
Because
where I
really,
should be there.
deeply,
I looked up the orders. I was there.
and as regards your matter, Mr. Pange,
My
how
lord.
many officers are there?
How many posts, my lord?
One court officer.
One post. One post.
And how many HJ are there? How many AOJ are there?
2, my lord.
2
Two.
AOJ.
Yes.
So here there is no problem.
No problem.
For you, I don't think there is a problem.
No.
Problem is maybe here because here the main issue involves is the moment you equate the post of court officer with AOJ, moment you equate the post of court officer with AOJ, then the problem arises is that the AOJ, his seniority comes from 2016. Whereas the post of AOJ, if you are those people who have bought their post of AOJ now, recently, they, although they are senior in him, to him in the HJA category, will be deprived. Isn't it? That I get done. That is what I say. There is a problem to the effect. It is not that you can deprive him otherwise than a court officer. He will come in. If you take the seniority, all the seniority in the SJ cadre, That is seems to be the only point. But for that, the petitioner out here in the ownership matter should not
Yes.
suffer. Because you have the equation of 1:5. There are only two AOJ
Yes,
and the court officer.
yes,
So definitely he will come within the ambit of the zone of consideration.
yes,
Fine. In the case of the ownership matter.
yes.
But in respect to the other matter, he made the question will arise as regards the equation of the post. Post may be there. So if the only way of harmonious construction which you say is not to read with the seniority of the AOJ, but to read it in seniority with the HJ for everybody. That is the only way out. Huh? Don't you think so? Then everybody thinks a person who is senior could get an opportunity. Have you seen the gradation list? This is the gradation list that they kindly come to the gradation list of the senior judicial assistant of the Guwahati High Court. Huh? Page? Ah. Yes. Now you kindly see here. এখন এনেকুৱাকে প্ৰিণ্ট আউট কৰিছে দুটা লিখা Right. Now you see in the latest gradation list, as per 19/3/19/2025, it is today, yesterday's date. The petitioner hearing is at serial number 17. He was HJA on 30/10/2013. Now there are other AOJs in the meantime. AOJs in the meantime.
And that AOJ were also promoted from LDA and UDA.
AOJ. No, understood. Huh? AOJ?
AOJ were also promoted from LDA, UDA. From UDA.
UDA. And what is the place? The air post from AA?
And that in the gradation list.
The AOJ, you see, now you have AOJs of 2019. The first, the senior most AOJ as of now is on Rajkumar Polita. Now he's of 2019. Now all these are from 2019. নতুন করেনি তুই তখন উঠে হয়ে গেছিলি। Peter is there. Now, all these people, there are a lot from UTA, PM. CM is? What is CM? Postmaster. Okay, Postmaster, then AOJ. So in the senior judicial assistant cadre also, the petitioner hearing is in number 17. Number 70 in the seniority, in the SJ cadre. Now, if he jumps into and becomes goes to the court officer AOG cadre, is equated, then in that regard, can his seniority be given anything else? And what was the requisition you said he has filed earlier, by which he was allowed to appear in the court of law?
2018, we filed one representation regarding the seniority, and that was rejected on the ground of 7-4. Rule 7-4. That in his promotion orders, it was reflected Rule 7-4 that that seniority will be maintained as per HG. His seniority.
In his
In the
promotion
court office.
to the court officer.
Now, against that, he has filed representation, which was rejected. We communicated him, and thereafter, again in 2021, he filed another representation. So he get human. He has, at present, he has no cause of action. Because when you regarding seniority, your representation was rejected. He should have come. All these years,
Or in other words, therefore your submission is that the AOJ for the post of the extent register, what do you call, the seniority has to be, the person to come within the zone of consideration, which is 1:5, has to be taken on the basis of their seniority in the HJ. Now, if it is done so, even for the case of those AOJ, so the issue which is being agitated by him here is 2C. 2C comes under 7.3. Very well. 2C comes under 7.3, so he can be he will be a person who can be there. But provided he comes within the seniority positions as per that. So the basic idea for rejecting the post of the case of the person from the Arunachal was wrong. Has to be wrong because there are only two. So he's the third. So he has to come in. There's no quarrel with them. So he should be allowed to participate. Whereas he cannot be allowed to participate in view of the fact that he was not there. He would not come within the zone of consideration, taking into account his seniority in the cadre of the exam. So that will be a harmonized reading of 7.3 with 7.4. But the only problem is 7.4 brings in AOJ. How do you read that? If you would not have put that AOJ aspect in 7.4, the problem would not have arisen. Don't you think so?
Just amendment, my lord, 7.4, it's not there in the book.
It is not there in the book. So therefore, you see, only see 7.4. 7.4, what he made, that is how the petitioner gets a case. Not this one. You won't find it in the book. What has happened is, to the post of assistant register, the seniority in the case of the, you see the feeder from 7.4, as per is that notification, for the post of the court officer, an AOJ can opt for it, and there could be a promotional post from the post of what do you call the
SJ.
HJ. Okay. Now so therefore it cannot mean that a person has been demoted from AOJ. Cannot mean. The post is equivalent. So here, the moment he goes from HJ, then so it is considered that it is a promotional post to the post of court officer. There's no quarrel with that. So it becomes equivalent. Now, the problem which arises is the AOJ is being made, seniority is made with the AOJ
Yes.
and not with SJ. If the AOJ seniority is also being taken with the SJ, then obviously it is a good case. Then it will be going as per the seniority from the HA cadre. Then a person normally would have got it. But making that, the moment you make him like this, what happens? This person concerned, the petitioner, became a court officer in 2016. These AOJs who are there, who are vying to get a promotion to the post of assistant register, they have been appointed much later. Get the point? This notification of 7.4 makes that big problem. This wording, it should have been said that the AOJ and the SJ court officer that shall maintain here as per the HJ. That should have been done. Can there be any other independent reading?
Their further promotion will be considered on that.
Now, therefore, he says that my post is equivalent to AOJ because a person cannot be demoted. And I went in 2016, others have gone now. But although without taking into consideration that those others were much senior to him, he is number 17 in the LCA. And there are many more AOJs still waiting. There are still now around AOJ who are waiting 26. 26 AOJs are waiting, whose appointment, who were as SJ much prior to the petitioner. And apart from that, there are another 16 in the SJ who are much senior to the petitioner. So thereby, 26% are being superseded if we include him. And that problem is because of that wording. We'll have it on 24th of April again. April. In the meantime, let's find a solution. We have got the gist of it. Now the solution is to that effect. How do we do it? if we read down this, that the fact that it is wrong, but I can't read down that because it's a rule. There can be any other interpretation given.
What interpretation we can bring into?
And as regards this case, should we keep it or should we dispose it allowing his petition?
My lord may allow the,
Officer can very well become an instant minister. There's no quarrel with that. He can. But the main problem is the seniority has to be taken from them. Even in his case, if the seniority is also taken, then also he gets it. Because he's number 3 against 1 post. Isn't it, Mr.?
yes, ma'am.
1:5 he comes. 1:5 he comes in.
1:5 he comes in, then, isn't it, Mr. Mukherjee?
Yes.
He comes within the ambit of 1:5.
No, affidavit, as the consolidated affidavit has already been filed. This is
Ah.
for entirety and para 6 of the affidavit, consolidated affidavit is the only stand of the High Court. Para
What
6.
does he say?
Six postable lines. Four of them
Yes,
are there.
yes. What is this?
Okay. The same thing, my lord, 7/4 has been relied on.
I think we can dispose of this.
Yes, if your lordship have page 38, my lord, your lordship will see there are only
The
two
fact
AOJs.
that 7-3, a court officer will come in.
Yeah.
But even in the case of an SGA, if you take the seniority from the SGA also, he comes with it.
How many SJ?
No.
In Stenographer. And it can.
No. A SGA cannot become a court officer.
Yes.
You see, the problem which is required is this. The problem is this. An SGA under no position can become an assistant registrar. An SGA who goes and becomes a court officer can become an assistant registrar. But in order to determine his seniority, the seniority has to be taken in such a manner that the SGA's seniority is to be taken for AOJ as well as the court officer.
Yeah.
If that is being done, then the purpose is served. That is the only way out. Don't you think that? That is the only way out. Otherwise, this will be depriving a lot of AOJs. Many people will be deprived who are much senior to him, even in the SJ. Now, he becomes a court officer, it's okay. He has a right of being promoted to this. Because of his post, it can be, but he comes. But the fact that he is lowered in rank in the SJ cadre amongst the AOJs, then he can.
I think but people have been. And if you go to their stand, the petition and.
You have not filed affidavit.
And it was right on the list. That it was being listed after the impeachment. My name was never shown. I never knew that this matter was being listed at any point of time.
I don't know that you have ever appeared before me.
Because that first list doesn't show me. My name
Obviously,
is not reflected. So I never knew this matter was being listed. Today, when I was in the court, I don't remember 11, I just heard the arguments and I thought that this should be my mind. I took up the. last one.
We'll do one thing. We'll have it on 24th of April.
Yes.
Showing your name. And in the meantime, let the Guwahati High Court file the gradation list of the of the Arunachal bench ministerial stuff. The latest gradation list. Then we'll get to know how it is. Although I don't think there would be a problem with hair case. But this is
Stenographer,
what
my
is
lord,
the
there are only two AOJs, my lord, and one court officer.
So because there cannot be more, SJs cannot become assistant minister.
Yes.
There's no quarrel with that. So it has to be taken from there. But if the AOJ is otherwise senior from the SJ, in the SJ cadre from the court officer, he will get if there are 10 AOJs, as in the instant case, that is the only issue. Okay, list this matter again on 24th of April, 2025. This court have duly taken note of that. You are paying for whom? This court have duly taken note of that by an order passed by this court on 10/6/2024. The respondent numbers 4 to 18 have been included. However, the counsel who appears on behalf of the said respondents, their names have not been shown. The learned counsel, Mr. R. Mujumdar, appearing on behalf of the said respondent, submits that they would like to file an affidavit in the instant matter. And as their names have not been reflected, they were not aware that the matter was there. He was not aware. So considering the above, this matter on 24th of April 2025. The affidavit of the respondent numbers 4 to 24, 18 be filed on or before 8th of April 2025. The petitioner, if advised, would be at liberty to file their reply on or before 22nd of April 2025. Further to that, upon deliberation, upon hearing the matter at length, this court would also direct the Guwahati High Court, Itanagar bench, to bring on record the latest gradation list of its ministerial staff.
Obliged.
Timing item 8.
Hey, big matter. Yes, nobody from the finance.
Also, people go into legs, lordship. It is
Oh.
not that it is not-
Okay.
I'm not aware regarding this. I'm not aware regarding it, but council people was here. But see, we have to go because there
So
was-
no affidavit has been filed. So we will pass directions, then you feel
No, no,
contempt.
I have seen the file, but the instructions we have received yesterday. Well, the instructions what I could find, some instruction. Some clarification has been sought from the registry of the honorable court. Kindly come to the last paragraph of E. Yesterday we have received E. With respect to paragraph, the deponent begs to state that after receipt of the information as sought from the department's letter dated so and so from the registry of the honorable court, this department had forwarded the said information to finance department by their for their concurrence of the proposal. The finance CC department had requested the department to resubmit the file in e-file with a copy of PPO in respect of Sri Vipul Bush, retired assistant registrar, Guwahati High Court. And accordingly, file was again resubmitted in e-file and forwarded to finance CC department for their concurrence on the proposal. The finance CC department, by their endorsement, had requested this department to clarify whether approval of the finance department was obtained before engagement of Sri so and so. As OSD, then the department has again requested the joint registrar admin, Guwahati High Court,
White letter number so and so dated 24/4/2023 to clarify the above observation of finance department, but when no clarification has been received, then a reminder was sent to the registry on 26.
So you want to give a post facto approval?
But, the response of the registry we have received on 10th of March 2025. Now that I have talked to them, today they are moving the file to the finance block. Then their finance will take their, finance will do that, with their concurrence and accordingly. There was some
The only problem is there was no sanction.
there was no sanction.
Now you give a post facto sanction.
The finance wants that, why, the reason. The reply we have, in fact, the registry's reply is copy with everything. Can you give us some time, Madam? By today, Madam, logical record it. I have talked to them. By today, they will send it to the finance.
No, it's okay. We will have it on. Can we get a further development on by 27th of March? You see, the person has worked.
Yes.
So
Today-
he's
today is
entitled to the amount. Question is if the amount, what can be done if there is a post facto sanction and all? Can be done something is good which will happen. So the High Court should have been more careful. It's a different thing. Also, then the next thing is we'll have to take it up on 24th of April.
But,
Let's try our luck on 27th. If any further development.
27, got it. My friend, my colleague, Mr. Gogoi was also there from finance department. I have also informed him that today we are sending it. Then what he will.
Let's,
take up
yeah, for a development.
On 27, we will apply.
Okay, Mr. Dina appears on behalf of the Judicial Department of the Government of Assam and submitted that on 10/3/2025, the registry of this court had furnished necessary information about the engagement of the petitioner, retired assistant registrar, as the retired assistant registrar, Guwahati High Court as the OSD. He therefore submitted that this aspect of the matter has been forwarded to the finance department.
They are sending it.
Now would be forwarded to the finance department for getting post facto concurrence in respect to the re-employment of Sri Vipul Bush. In that regard, he has placed before this court an instruction issued by the Joint LR and Joint Secretary to the Government of Assam Judicial Department, which is kept on record and marked with the letter X. But taking into account, this court had also inquired with Mr. B. Gogoi, the learned counsel appearing on behalf of the Finance Department, as to inquired as regards the proposal. He submitted that the moment the proposal is received, the Finance Department shall take appropriate steps. So this matter on 27th of March 2025 for an update.
Item 15, fixed at 2 p.m.
Yes. Tell me. Are you vacating the land or not?
That is not contact, my lord. They wanted to talk to them, my lord. But yes, sir, I think that.
You get some time to vacate. That's the only way. There's no other way but to vacate. Because the ACC doesn't have the money to purchase. That I know, you also.
I am not.
The ACC had no money to purchase. So the only way out is to vacate. How much time? Then I can close the land grabbing. After all, it's the government entity which should close it, but you need to vacate. Don't you think? Mr. Fukon would not mind, would not further indulge in that proceeding if they vacate and give the possession. When?
Hello?
When? Give me an update by Monday, Tuesday. Give me an update by Tuesday when you are vacating. You have to vacate. There's no way out. Because I don't want tomorrow that it will be it will show very poorly with the MD tomorrow being of the ASTC being put behind the bars. Because he's also responsible being the MD. Because it's apparent a case of land grabbing. You have to vacate. There's no query. He's filing all these things doesn't have. Hmm? What is there? Good. Without wakalat number?
What happened, my lord, department, my lord,
Department is different, but this is an entity, this is a corporation. Corporation is different from the government of Assam department, where it's a different thing by which the governor appoints. Here the governor doesn't do it,
I don't know,
the MD gives it.
this is going on, my lord.
No, it's not like this.
Anyway,
You see, for earlier Mr. Jyotimal Roy and all these people were appearing. So their signs are there. They have appeared. They have put their wakalatnama. Then, how is it possible?
we have filed now. Today we have filed.
Okay. This matter again on 25th of March 2025 at 2 p.m. Pusta. Mr. Jihan Savela, the learned senior counsel appearing on behalf of the ASTC. The petitioners shall apprise this court as to when, within what time the ASTC authorities shall vacate the land in which.
How long?
Item 19, fixed at 2 p.m.
Hmm. Oh yes, what case you have? Withdraw?
No, Lordship, I would like to make some point.
Please.
Lordship,
Let us go as per the calculation. Let us make it very simple.
yes,
When was the trial court judgment delivered?
right. Trial court judgment is Lordship 31/7/89.
31/7/1989. Then first appellate court,
First appellate court on 12/8/90.
12/8. Second appellate court,
Second appeal is on 14/8/2001.
14/8/2001. And when did you file?
Application filed on 25/9/13.
Now tell me, how do you
Yes.
escape the period of 12 years?
If Lordships kindly, because point to be decided here, from which step for Article 136 of the Limitation Act, from which step in the present fact situation of this case, the limitation will come. So for the Lordship, kindly see their application. Here they have mentioned,
No. Whatever the application. Your application, I'm not concerned. Which date it will apply means from when? As per you,
now your Lordship, in a trial court, 1 month time was given to hand over the possession. Then appellate court modified that term. It says the 3 months. Then second appellate court on merit affirmed the degree of the appellate court. Now Lordship, second appeal is dated 14/8/01. And that 3 months Lordship,
will expire on 14/11.
Yes, 13 or 14/11/01. So from that date, the decree can be executed enforceable. So Lordship, the 12 years will be on 12/11/30. 12 years from 13/11/01. So we have filed on 25/9/13. So it is within time. And Lordship, 136 also says, when recovery of possession is involved, on the date of default only time will run. Date of default means after expiry of this 3 months, because court even that 3 months, we cannot enforce within that period of 3 months. So it will be enforceable after 13/11/01. And Lordship 136, it says, when the decree or order becomes enforceable, or where the decree or any subsequent order directs any payment of money or delivery of any property to be made at a certain date or at recurring period, when default in making the payment or delivery in respect of which execution is short take place. So they have defaulted after 13/11/01.
That's it.
Yes, Lord.
What do you think?
My submission is, my lord, trial court judgment says that within 1 month, recovery. And the trial court judgment, the lower appellate court judgment given 3 months time. But that has been gone also. Because the second appeal judgment is, lordship, when affirmed the title of appellate court judgment lordship, they have not time figured any file. So only dismiss the title, the second appeal. Have not any period bracket be left. I will reply on there.
You are appearing for?
Respondent number 2.
Who is respondent number 1?
Respondent number 1, right.
Well,
The year 2015.
As part of Lordship, as part of Lordship, HCR Lordship, execution, the substitution was made, but the thing was, this, hospital and all were not corrected.
here substitution done.
Not here, Lordship. In the execution,
So we are filing against the dead person.
yeah, that was the mistake. It was my,
So do we dismiss this petition?
that is why he prayed Lordship to aid those persons.
To dismiss this petition on that ground.
Because Lordship,
When he was done, so you filed up against the dead person. No, you have filed up against the dead person.
But on the matter, the execution petition is no mention that matter they were substituted. That's basically 35.
Because they filed a 47 application.
Both one and two.
So when they filed the 47 application, so therefore the 1 and 2 have both they have been allowed. So therefore you have not challenged against the one who have filed it. So how do you challenge it? No. Third, Mr. J. Dekha, the learned counsel appearing on behalf of the petitioner. And Mr. So-and-so appears on behalf of the respondent number 2.
My fault, my.
I can't help it. I can't help it. They died before. When did they die?
2015.
That is not.
Then who filed that application?
that, died Lordship, the judgment date, he filed that application. Year 2014, 47 application.
Then there was substitution done.
Substitution done as per the order, Lordship. But it was not corrected in the petition and all.
I see that the respondent number 1 had expired in the year 2015, as would be apparent from the NCR. And
Lordship 22,416. Order dated 22,416. That flag mark is there. We have filed substitution petition
Your file substitution where?
before the execution court. And it was allowed.
The respondent number one had expired in the year 2015. And this very aspect of the matter could be seen from the order dated 2/12/2015, wherein the petitioner had filed an application intimating that the respondent number one had expired. On the basis thereof, the substitution was allowed by an order dated 18/1/2016.
And they appeared on 22/4/16. Order.
No, this is for the execution. What about the section 47?
Section 47, they did not include because they did not, because it was kept in event. Main case was kept in event, they did not include and during their death that this order was been passed, in order. So other way around, Lordship, that was abated, that petition itself is abated, section 47. Only one lady, Lordship, filed that petition, 47.
Who had filed the petition?
Put the dependent.
And your petition is where?
This is the application, but the jointly filed.
Both, not both, Lordship.
It was a joint application.
Yes.
No, only one signature, yes.
Mr. Abul Wahid and Kabul.
Yes, Lordship. Both filed. But during the tendency of section 47, the Abdul Wahid died.
Okay, they did not
They did
substitute.
not substitute with themselves in section 47. And if you know that is passed on the without substituting this Abdul Wahid.
Okay, so that would not, we strike out the name of the respondent number one here. Taking into account that he did not bring in, so there was no necessity to bring him here and allow your petition. You see, he filed a 47.
Yes, he also.
He filed a 47. He did not substitute that applicant in his miscase. If he was required to file an application in that in miscase, don't you think so?
Section 47, I think. 47, they should have, because main case was kept in events.
So when you were supposed to substitute, you did not substitute.
Section 47.
If you have not substituted, it's the same council.
Same consistent petition, signature is there. Both parties. That verification was filed by
That
Abdul
application
Wahid.
is, that application we filed before this, the executing court, Lordship, on the basis of his execution judgment. And we are intimated to the court in the year 2015 that the respondent number, judgment number one is died, Lordship. And accordingly, they have filed a petition, Lord. Lordship. My duty is, Lordship, already over, Lordship, because I already intimated the court, Lordship.
No,
This
for
is-
that in the decree, which they have done it. But this is your petition to nullify the decree. I'm not asking for nullification of the decree.
execution proceeding filed by the decree will start. They only pointed out only this point, Lord, limitation point. In the section 47, nothing else. And whatever the anomalies of the schedule 4 was rejected by the imperial order itself. Discrepancy of 3 katha, 2 katha.
Where is the first appellate court judgment?
That judgment is considered page 59, and it is filed by only Abdul Wahab, not by the JD number 2. He was a made pro forma respondent at page 59 and except 4.
What is the date of the judgment?
Date of the judgment,
First appellate court?
12th August 1994 by the district judge Walpara.
Twelfth of August,
1990.
giving you 3 months.
3 months. Earlier it was 1 month.
So you ought to have vacated by 11, 2019-94. Then it merged with 14-8.
Yes.
14-8 makes it that you are to bear.
So 12 years will be expiring on November 2013. We filed on September. The court's conduct finding regarding my right second
So here, can we not import the provision of Order 41 rule
That notice is ready to, before the second appeal also, he was court-martial respondent before the High Court.
Who?
JD number, judgment debtor number 2. He did not prefer the first appeal. Even in second appeal also, he was a court-martial respondent. Lordship, order 41, rule 14(4) is there.
14(4).
Subsection,
Ah.
notwithstanding anything
Notwithstanding anything in the
contrary contained in
country
sub rule 1, it shall not be necessary to serve notice of any proceeding incidental to an appeal or any respondent other than a person included for the first time in the appellate court unless he has appeared and filed an address service.
No, 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 not this. Not that thing. This, order 41 rule 20. Where it appears to the court at the hearing that any person who was made a party to the suit in the court from whose decree the appeal is prepared, but who has not been made a party to the appeal is interested in the result of the appeal, the court may adjourn the hearing to a future date to be fixed by the court and direct that person to be made a party. No respondent shall be added under the rule after the expiry of the period of limitation of the appeal, unless the court, for reasons to be recorded, allows that to be done, and in such circumstances with cost and otherwise. This is done under what provision? 115.
Which one, Lordship?
115. 227. The 227, there is no limitation. So why don't you do in the idea of order 41 rule 20? Because it's 227. So you can bring in, because they were a party out there. They have already been substituted. So why don't you bring in two debt process? Subject to cost. 1 lakh. 1 lakh. 1 lakh is the cost. We'll have it on Tuesday, finish it off.
They are already entering Lordship.
Therefore, 1 lakh cost. 1 lakh is the cost. Otherwise, I don't, because here it says as to other cost and otherwise.
Otherwise, I had to from my own.
You should pay, both of you.
I do not have so much.
Both of you.
My mistake.
So,
Otherwise also, they are still enjoying that property, Lordship, which are enjoying by them, though we have a decree in our favor.
1 lakh, 1 lakh.
But
1 lakh cost should be given, both of you.
some other case, Lordship.
50,000 to Mr. Join.
Other is another.
No. File your application by tomorrow. Yes. Here we make them a party and comes with order 41 rule 20. Flavor of order 41 rule 20. They were parties out there. So we bring him here. Subject to cost.
This is a shared.
What?
The civil rule. Civil rule.
Against 47 order, Lordship.
This is filed under 227. 227, no limitation. And we allow this petition because the period is 3 months. Possibility from 136 will come 12 years from the date of non-compliance to the enforcement. So 3 months were given to them.
Enforceability, that 3 months is already gone. Because RSA did not.
We'll go by Anandi Lal. And there is another judge. Anandi Lal is enough.
Watching, regarding that enforceable, given that paragraph, when a decree become enforceable, normally a decree or order become enforceable for its date. But cases are not unknown when the decree become enforceable on some future date or on the happening of a certain specified events. The expression enforceable has been used to cover such decrees or order also which become enforceable subsequently. Well, Lordship, this 3 months. 3 months we cannot enforce in the 3 months. default, here not language of Article 136 is.
In the last line, the doctrine of merger does not make any distinction between an order of reversal, modification, or order of confirmation passed by them. The said doctrine postulates that there cannot be more than one operative decree governing the same subject matter at a given point in time. An appeal is prescribed under the statute, and when the higher forum entertains and passes an order on merit, the doctrine of the Which paragraph you were reading?
Not that judgment, Lordship, that is 2001 one SSC 469.
That is Ratan Singh.
Here, Lordship, one differences is that in our second appeal was decided on merit, affirming the appellate court.
Here the second appeal was dismissed on the ground of limitation.
So it says that don't come within the delay. That is why in this case from the appellate degree, it was here also, Lordship, like in our case, the term is modified. So here also, Lordship, the cost part was modified by the appellate court. So from the appellate court, first appellate court, the period was calculated since the second appellate court order is not a decree. But here in our case, it is affirmed. So it will be, and their case itself, 47 days, they said itself, all this, they did not include that 3 months period in their calculation in section 47.
No, there is another judgment of 2014 of Justice, I think. Oh, this is not 2014, 2004, 8 SCC 724. Sandeep Prasad. This is exactly your point. Once a decree is sought to be enforced for the purpose of execution, irrespective of being original at the date of the decree or any subsequent order directing any payment of money or delivery of provision or at a certain date, would be considered to be the starting point of limits. So therefore, here it is. There is no quarrel. Therefore, I would have allowed. The only thing was this, for which you both of you shell out 50-50 each.
Lordship, we do not have a degree of men's profit also, Lordship. They are enjoying that
Can't help
property,
it.
Lordship. Let them enjoy
Whatever will
the
be.
Lordship decide degree.
When are we filing this application?
Right.
This is matter on Mr. J. Deka, appearing on behalf of the petitioner, submits that he will file an application. Submits that there was an inadvertent error in filing an application, in including the respondent number 1. In as much as the respondent number 1 expired in the year 2015, and the respondent number 1 was duly substituted by the legal representatives before the executing court. He further submitted that even in the proceedings under section 47, from which the present order, wherein the impugned order was passed, there was no substitution being made of the judgment of the applicant. So, be that as it may, he submits that keeping in tune with the provisions of, in the spirit of Order 41, Rule 20, the petitioner would like to file an application for bringing on record the legal representatives of the respondent who had expired even prior to the impugned order being passed. So the said application will be filed in a day or so. This the matter on 26th of March 27th of March 2025 at 2 p.m.
Deeply obliged.
1 lakh. Together from other matters. Yes. Can't help it. What's this cost? He does. You were the person who was appearing in that matter now with these sort of You the person,
I was earlier engaged as a council lawyer.
no,
Subsequently,
you are not in this, that matter. You were not there.
in once here being also.
Here,
It's
order
that
9
was-
13.
His thus was there also from the other side. His thus. Also was disposed of recently.
I disposed it of, but you see what I thought at that point of time. Some cost is to be imposed upon the petitioner. I said 50,000, then I said 25,000. But the fact that the apparent mistake on the part of the court, I can't impose this cost because of the fact that, you see, it is not conceivable how the court behaved. In a matter pertaining to Order 917, the law is very clear that the defendant can participate at any time of the proceedings. There's no quarrel with them. On a day when it was fixed for the lawyer, a change of the lawyer of the plaintiff, the trial court on that date it fixed the proceeded ex parte against him. Okay, they may so do so. But thereafter, when the evidence was filed, this person wants to cross-examine, he was stopped. When he wanted to give evidence, he was stopped. It absolutely encourages, and if I impose a cost upon you, it doesn't reach the conscience of the court. So tell Mr. H.K. Das, I'm not imposing the cost. I remove that cost.
Yeah, I was at the process
No,
subsequently.
this is not a case where because although I kept it okay, I'll say that I disposed it of by imposing it. The counsel for the petitioner agreed, but if he agrees also, means for me to impose upon him a cost of 25,000 means cannot be done because it was an apparent mistake of the court.
I'll come.
Yes, tell me. How is there a stay
No, Lord,
to the suit proceeding?
no, Lord, the stay was not our prayer, Lord, pleadings, Lord.
You have told the court they shouldn't have stay to the suit proceeding.
Actually, after the notice was issued, yesterday was the first day here. So I did not get the
Tell me.
opportunity.
What is that?
No, Lordship, initially, we filed a title suit, Lordship. And title suit, and along with the title suit, there is a miscase. This Lordship, at page 139, the trial court was pleased to pass an order of status quo, Lordship. At page 139.
What is your suit for?
For also declaring the proposed action to be taken by the respondent Congo as unconstitutional and illegal laws. And also permanent injunction restricting from taking the disciplinary action of for that's amongst the boycotting and practice.
Because doctor, he asked for from these, what were their actions?
Consider they issued the 4 different letters also. At page 55, 55 was the first letter.
For what?
Then they actually also one celebration was there also. 24th number Kendra Tiku Zubo Aimate Famaro. That present petitioner was the Pradhan part about that celebration also. And subsequently, lots of after conclusion of the celebration, the audit was taken place. The entire account was submitted before the, as per the procedure, also, it was submitted and it was accepted. And but thereafter, going in an unconstitutional manner, also they have issued certain communication asking the present petitioner to submit the documents for reissue. That was we challenged the entire these 4 letters. Also.
So what
And
is
the
wrong
suit
with that?
The suit is pending. Also, the issues were from hereafter.
Oh, what?
Respondent.
But how do you ask for declaration? Okay, you may say that the unconstitutional, whatever may be, they're asking for this because the letter dated. You are asking a decree by declaring the letter dated so and so and so and so issued by defendant through defendant number 5 to the plaintiff as well as the letter dated so and so, asking for documents and records of audit number so and so. And here is unconstitutional for the purpose. Why?
No, Lordship, as per the rules, that was discussed, that's what relied upon by the plaintiff, and petitioner as a plaintiff here. The rules doesn't suggest that. Rules, once the audit was prepared, that is presented before the district committee as well as the central committee, and they accept the whatever the remaining residual part of the collection of that celebration losses. Thereafter, there cannot be any re-scrutiny on that loss. There is no provision as such. So they were proposing to re-scrutiny, have a re-scrutiny after collecting the documents from the visitor. That's why they were there. And the suit was.
And this was vacated by what order?
Consider initially, may I first take your lordship to page number 139, in initial order.
139. I've
139.
seen this. Now tell me what is the next order? Is it only a
Next
F
order
copy?
is at page number 213. Initially, status quo order was given by order dated 7/4/2021 at page 139, and thereafter it was vacated by order dated 8/12/2021. Simply relying on the submission made from the opposite parties, the respondents herein, they are saying that they are not proposing to take any disciplinary action at that point. Last part of page number 22 also.
You have been asked to give certain documents. Well, what is your problem in giving?
No, no, sir, as per the rules that have been framed by the Srimanta Sangote Congo, that is not required, Lord, sir. Once the audit was finalized, it is accepted. Lord, sir, if any action that is asked to be done thereafter, Lord, sir, that is not as per rules, Lord, sir. That is the.
Can you see the rules very good?
Rules are relevant rules. Rules doesn't say so, Lord, sir. I have a photocopy. Rule number 18 and 22 are relevant. And this is the Srimanta Sankode Congo Party Body Vekoner Adorning Committee Upavati. It's formulated on 14/7/2007. This is the requirement also, 18 and 22 also.
So you were supposed to submit all the documents.
Yes, Lordship. The petitioner has already get everything audited and it was presented, Lordship. And the 25% was supposed to be got by the district committee and 75% goes to the central committee. Everyone at the SEC has also been disbursed. Lordship. And thereafter, they were asking for certain documents for re-screening. And as per rules, that is not, there is no such rules regarding any re-screening. That's why we.
So if there are no rules, if there is some allegation of something that there is something has not been done properly, and this re-scrutiny, what is the problem in re-scrutiny?
But everything, the scrutiny has been done. It was presented as.
Understood, but what is the problem in giving it for re-scrutiny these documents?
If something is not required as per the rules, Lordship, can it be, can the petitioner or any other person get forced to do that, Lordship? It has to be because they are governed by these rules, Lordship. They are governed by these rules.
No, you, as per the rule, you were supposed to submit.
As per the rules, we have complied with it.
As per the rule, you were supposed to submit, and as per you, you have submitted.
Yes.
And on the basis of which the audit was carried out.
Yes.
And the audit was accepted.
Yes.
So therefore, now you say that there is no necessity.
Yes.
Now they feel that you have not submitted all the documents.
But we have submitted all the documents. We have all the acknowledgement. Even
No,
from
is it barred under the rules that if at a later point of time they find that the audit which was done was not done properly from exercising their rights?
that was initially, that was not the, in fact, the primary allegation. They are simply asking for the documents, and at the last letter, 25/2/2021, they were proposing to give blacklist or boycott the
There
president.
is no block, but they categorically say that we are not blacklisting or boycotting. What we will say that he will be suspended pending disciplinary action. That's all.
But as per my information also, by this time, even the annual membership, renewal of annual membership of the present petitioner has not been done also. That amounts to blacklist and boycotting also from the Hong Kong also. There is a system also, every year, there is a renewal of the membership also. And 2000, this is the latest development also. 2023-24, they have accepted the fee, and there is one tradition loss, Musti done. They have accepted all, but thereafter they are not renewing the membership also. It amounts to blacklisting of board. Having being the order from this honorable court also, not to boycott and members. Possible, we will face, the suit has been presented by the present petitioner also. Suit will run also. We have no objection on them. Even we don't have any prayer to.
No, when they are categorically saying that they are not going to blacklist you,
But
they are only,
there's subsequent action also. There's subsequent action.
but you have not amended your claim.
No, Lordship,
If there is subsequent action, how can this court
but
take note
Lordship,
of?
I kindly see the 25/2 letter once, so the SMS portion.
Page,
Page number 107. 107, the SMS particular portion is at 109. May I read, Lordship? I am reading the relevant portion of it. ভক্তিপূৰ্ণ সেৱা গ্ৰহণ কৰিব 16/9/2020 তাৰিখ বুধবাৰে শ্ৰীমন্ত শংকৰদেৱ সংঘৰ 90সংখ্যক বৰ্ষৰ দ্বিতীয়খনি মূল কাৰ্যনিৰ্বাহী সভাৰ সিদ্ধান্ত আপোনালৈ প্ৰেৰণ কৰা হৈছে যদিও আপুনি 8/11/2020 তাৰিখে অনুষ্ঠিত হোৱা শংকৰদেৱ সংঘৰ 90সংখ্যক বৰ্ষৰ তৃতীয়খনি মূল কাৰ্যনিৰ্বাহী সভা পৰ্যন্ত কোনো উত্তৰ নিদিয়া বুলি গুৱাহাটী মহানগৰী জিলা শাখাৰ প্ৰতিবেদনৰ জৰিয়তে তথ্য পোৱাত পুনৰ আপোনাৰ শ্ৰীমন্ত শংকৰদেৱ 24 সংখ্যক কেন্দ্ৰীয় শিশু যুৱ আৰু মাতৃ সমাৰোহ গুৱাহাটীৰ চূড়ান্ত নথিপত্ৰ পাছবুক সহ 15/3/2021 তাৰিখৰ ভিতৰত গুৱাহাটী জিলা মহানগৰীৰ শাখাৰ সভাপতি সম্পাদকৰ হাতত জমা দিবলৈ আহ্বান জনোৱা হয়। অন্যথা নিৰ্ধাৰিত সময়ৰ পিছত আপোনাক সংকল্পটো প্ৰাৰম্ভিক অনুমোদন হিচাপে সংপৰ্ক ৰহিত কৰা হ'ব। This is their proposal also. And subsequent to that we.
অথবা নির্দিষ্ট সময়ের ভিতৰত নিদিলে this will be done.
Yes, boss.
You were supposed to give.
Within that period of time, we submitted.
So are you agreeable to give now?
No, boss.
Then no case.
No, Lordship,
Absolutely no case. With this,
no, Lordship, then let me take the instruction.
no instruction, business, nothing. This is
Let
the-
me take.
First of all, an internal matter of a society, the court's jurisdiction is very limited. That is the law. We don't interfere into this, and that too when he is asking for financial transaction. Everywhere you go into the question of transparency, you were asked to submit this passbook and all. Why you are not submitting?
No,
What is wrong?
if it is not required as per rules,
As per rules, forget about the rules.
then
Go to
let me
Supreme
take
Court.
instruction as to whether he will submit or not. Because the entire proceeding is under challenge before the learned trial court also. Issues are.
Mr. Roy.
Right.
You are not going to blacklist or boycott him.
We have temporarily suspended that.
Because you have not given him. You have temporarily suspended him. It's okay. Now, if he gives it within 10 days from today, you are removing his suspension.
Inquiry, but there is a.
Inquiry, you hold this inquiry, but you are not going to boycott or blacklist
No,
him.
We are temporarily suspended. Remain under temporary suspension.
No,
till the
Mr.
inquiry is over.
Mr. This is not a case.
When it is not required as per the rules, even the issues are also federal.
Mr.
So let me, can it be on Monday?
No,
As a partner.
no,
as
no, no.
partner, boss.
This type of matters should not be there. I was shocked when I saw this matter. This type of matters cannot happen. Heard Mr. J. Das,
at least
J. Das,
on
the
Monday,
learned
no.
counsel appearing on behalf of the petitioner, and Mr. J. Roy, the learned counsel appearing on behalf of the respondent number 1256. The petitioner herein has invoked the supervisory jurisdiction of this court under Article 2 to 7 of the Constitution, challenging the order dated 10/10/2023, passed in Miss Appeal number 4/2021, whereby the appeal filed by the petitioner was dismissed and the order dated 8/12/2021, passed in Ms. J case number 212/2021 by the learned Munsif number 3 Kamrup Metro at Guwahati was upheld. The question arises in the instant proceedings as to whether this court, in exercise of its supervisory jurisdiction, is required to exercise the in exercise of the supervisory jurisdiction, should entertain the instant proceedings. The materials on record reveals that the petitioner herein as plaintiff claims to be a member of the respondent number 1, who was elected as the General Secretary of the 24th Kendriya Shishu Yuva Aru A. Matri Samaru. It is the case of the plaintiff that on successfully concluding the Samara, SAMARA, the petitioner had filed the audit report of the Samara to the respondent number 1 herein as per Article 18 of the Constitution of the respondent number 1, detailing the expenses of the Samara. The petitioner thereafter It is the further case of the petitioner that thereafter the respondent number 3 herein had withdrawn an amount of rupees 2,59,500 out of the saved balance of the Samara. Subsequent thereto, the respondent number 3 issued notice to the petitioner through the respondent number 5 seeking rescrutiny of the Samaro and demand records and documents relating to audit. The petitioner's specific case, the specific case of the petitioner, that such scrutiny of the audit, re-scrutiny of the audit is not permissible as per the constitution of the respondent number 1 and the general secretary of the respondent number 1 has no power to do so. On the basis of which title suit was filed, being title suit number 244 of 2021 before the court of the learned Munsif number 1 Kamrup Metro at Guwahati, which was subsequently endorsed to the court of the learned Munsif number 3 Kamrup Metro at Guwahati. Along with the said suit, the plaintiff had also filed an injunction application which was registered and numbered as case number 212 of 2021, whereby the petitioner sought for an ad interim temporary injunction restraining the respondents herein from passing any order and or taking a resolution to Songharo ito SONGHAROHITO inverted comma ito word, that is blacklist of boycott the petitioner as proposed in the letter dated 25/2/2021. The record further reveals that the learned trial court, by an order dated 7/4/2021, passed an ex parte order directing to maintain status quo till the disposal of the said injunction application, so that the determination be made in the main title suit are not frustrated. Subsequent thereto, the respondents appeared and filed their written statement as well as the written objection. The case of the respondents in their written objection as well as the written statement is that the petitioner had submitted incomplete and wrong audit reports, and the executive committee, after perusal of the reports, had issued letters to the petitioner seeking relevant documents for re-verification of the audit, but the petitioner had not paid any heed to the same. It was the further case of the respondents that by letter dated 25/2/2021, there was no mention of the fact that the petitioner would be blacklisted. And the actual word used was SANSARCAROHITO, inverted comma, which means temporary suspension as a preliminary disciplinary action. The respondents have further stated that the Sangha had no provisions for blacklisting or boycotting. It is under such circumstances the respondents have paid for dismissal of the suit as well as for rejection of the injunction application. After filing of the written objection, the learned trial court heard the matter, heard the injunction application, and by an order dated 8/12/2021 came to a categorical opinion that the petitioner had a prima facie case. However, taking into account the respondents herein had only intended to initiate disciplinary action against the petitioner, which the petitioner had misinterpreted as boycotting him, comma, the learned trial court came to an opinion that there was no balance of convenience in favor of the petitioner for grant of an injunction. Taking into account that as there was no balance of convenience for grant of an injunction, it was also held that the petitioner there would no irreparable loss, harm, and injury would be caused to the petitioner. It is on that circumstances, by order dated 8/12/2021, the injunction application was dismissed. Being aggrieved, an appeal was preferred, which was registered and numbered as Miss Appeal number 44/2021. The learned first appellate court, after taking into consideration the three golden principles for grant of an injunction and applying the same to the facts of the case, came to a categorical opinion that there was no requirement for the purpose, there was no requirement to interfere with the order passed by the learned trial court dated 8/12/2021. Being aggrieved, the present proceedings have been filed. This court have heard the learned counsels appearing on behalf of both the parties at length and have also perused the materials on record. Mr. J. Roy, the learned senior counsel, appearing on behalf of the respondent numbers 1 to 5, submitted that the respondents were not taking any steps for blacklisting of the petitioner. What steps were being taken were that the documents on the basis of which the earlier audit report, audit proceedings were initiated, were sought for. And in accordance thereto, however, the petitioner refrained from giving, and it is under such circumstances the communication was issued to the effect that if the petitioner failed to give within the period of 7 days from the date of the issuance of the communication, the petitioner would be suspended. He submitted that when it is a case pertaining to the internal affairs of a society, the court's jurisdiction to interfere is very limited. This court have also heard the learned counsel appearing on behalf of the petitioner, who insisted that from the materials on record, including the constitution, it would be seen that once an audit has been carried out, there is no question of again resubmission of the documents. He submitted that when the rules are made of a society, those are required to be adhered to. And if there is any violation to the said rules, the civil court has the jurisdiction. Having heard the learned counsels at length, this court finds it very pertinent to observe that the jurisdiction of the learned of the court to interfere in the internal affairs of the society is very limited. In the instant case, from the facts stated, it would be seen that the respondents herein is of the opinion, and the respondents herein wants to make re-verification of the audit. And as such, I have asked the petitioner for production of certain documents. Because the production of the said the petitioner, however, is averse to production of the said documents. Because the issue involves as to whether there has been certain misappropriation of money. Because the question as to whether the respondents' authorities, the respondents herein have a right to make such audit is an internal matter of the society, merely because of the fact that in the constitution there is no specific provision for re-scrutiny. In the opinion of this court, it cannot be said that the respondent authorities, more particularly the respondents would not have the power to seek for the documents on the basis of which the audit was made. Consequently, this court further takes note of the specific the specific stand of the respondents, wherein they state that they are not going to blacklist or boycott the petitioner. What they intend to do was, if they don't submit the document, what they intended to do by issuance of that communication is that if the petitioner failed to submit the documents, the petitioner would be suspended pending disciplinary inquiry.
Suspended by that.
That was the letter. That was the letter.
After that also.
No, that was the letter for which you issued.
Yes.
That we will suspend you and pending disciplinary inquiry. Subsequent thereto, as the petitioner did not produce the said documents, the respondent authorities have suspended the petitioner and some disciplinary inquiries is going on.
It's not one.
Not going on?
Not because of the interference of the
Suspended the petitioner, but in view of the suspended the petitioner, Mr. J. Roy submitted, the Senior Council submitted that in view of the order being passed by this court, the disciplinary proceedings could not be proceeded with. Also, taking into account the above, this court is of the opinion that taking into account the above facts and the fact that the learned trial court as well as the learned first appellate court had exercised its jurisdiction, discretionary jurisdiction in accordance with law, this court is of the opinion the question of exercising the supervisory jurisdiction of this court does not arise. Accordingly, the instant petition stands dismissed. Before parting with the record, this court makes it very clear that the observations made herein are only for the purpose of deciding the instant application pertaining to the injunction proceedings. The same, however, shall not influence or affect the adjudication of the suit. Taking into account that both the parties are duly represented, the stay order dated 1/3/2024 stands vacated, and the parties are directed to appear before the learned trial court, that is the court of the Civil Judge Junior Division number 3, Kamrup Metro at Guwahati, on 4th of April 2025 for further proceedings of titleship number students.
All right. Okay. Admission item 18. That the post of process server that which was advertised. So that is the direct input. And on another post is vacant on 28/2/2025. That is a promotional post.
Oh, you filed the affidavit?
Yes, ma'am. That post is a direct recruitment post, you know, which has been sought to be filled up by the impune advertisement. It's
You
not,
will be given later on.
yes,
How are you encroaching upon somebody else?
I'm not,
This post was, that advertisement was only for direct recruitment, for direct recruiters.
Only one post was advertisement issued for one post lordship. And subsequently, as per affidavit lordship, another post has vacant on 28/2/2025. That will be the promotional post. And they are saying that the promotional case will be considered in respect of that. Post. But in view of that, this recruitment may be dismissed. And paragraph 10 of the affidavit. Page 29.
28 to, you know, another post fell vacant, 28. That page 30,
Page
below,
30,
last line.
last 3-4 lines. of-
Page 29.
It starts from
We
page
start
29.
We start from 29 and the lordship page 30, the last 3-4 lines.
Pertinent to mention that Honorable High Court had been pleased to direct all appointing authority to follow the draft rules area while filling up the post of process server by way of inference. In the draft rules area, no quota has been fixed for filling up of the post of process server and it can be filled by promoting as well as directly. The advertisement dated so and so is not in violation of the directions of the board. Hence, the recruitment can be done both through the process of direct recruit as well as promotion. The promotion of the petitioner will be considered as and when the post held by direct promoted so and so falls vacant in due course. In fact, the post held by the promoted processor will fell vacant on demand, which will be by promotion. So you will be by promotion.
That will be by promotion.
For sure.
Yes. So,
So we close it on the basis of that. Because the earlier part of that petition, the paragraph is a bit dicey.
no, higher part will also is not equal to go into, because since he came thinking it to be a promotive post, so that's why it, but since there is a post, he otherwise also may not, he'll receive consideration, because there is no ratio fixed. Because there is another aspect that he came here in this establishment by way of own request transfer. So he is a bottom.
Mr. Counsel, let us make it very simple because I don't want to go into the question of can the High Court direct following the draft rules.
No, not at all required. No, but I am
So
saying.
you have made it unnecessary.
No, it has been said because there were some pleadings in the writ petition, that's
They
why.
may say many things. You have to keep quiet now.
Fine. So this issue is there and that.
So when I left, the instant petition was filed by the petitioner who is the peon.
that
Who was the peon appointed by an order dated 23/11/2015, and he joined the service on 1/12/2015. The petitioner herein was transferred to the court of the SDJM Bilasipara under the Chief Judicial Magistrate Dhubri, and he joined the establishment on 10/9/2018. The promotional post to the post of the peon is the process server. The grievance of the petitioner is the advertisement issued on 14/10/2024, whereby the post of the process server is sought to be filled up by way of direct recruitment. It is the case of the petitioner that if the safe post is being filled up by way of direct recruitment, it would the petitioner's avenue to be promoted to the post of to be considered for promotion to the post of process server is being affected. Mr. The Guwahati High Court had filed an affidavit in opposition pursuant to the order dated 19/2/2025. In the said affidavit, it has been categorically mentioned that the post which was advertised by the advertisement dated 14/10/2024 is a post which arose out of on account of the resignation of one Srimati Tonurupa Goswami, who was directly recruited. It is further stated more specifically in paragraph number paragraph number 10 that a post in the uh, the post of process server in the same establishment had fallen vacant on 28/2/2025 on account of retirement, on account of
That instruction is not.
had fallen vacant on 28/2/2025
Okay, yes, but it's a retirement.
on account of superannuation of the incumbent. It was also mentioned that the said post would be filled up by way of promotion. Taking into account the above, the learned counsel appearing on behalf of the petitioner submits that the petitioner has no grievances,
And appeal, yes, to that,
has no grievances in view of the fact that the post which has fallen vacant on 28/2/2025, the petitioner can be considered for its promotion. Taking it in that view of the matter, nothing further survives in the instant petition for which the same stands. Considered for promotion subject to eligibility.
Yes, and seniority, because seniority is also an aspect.
Otherwise, no.
yes, but that will put.
Subject to eligibility and seniority. Eligibility, I think eligibility is okay, no? Both
It will be the same thing.
eligibility and seniority.
For others, item 10.
That depends, I think, was, well, at one sentence, but for
Huh?
promotion, post will be undertaken was it.
What is this RSA for? Review? What have I done? Oh, Mr. Kadir, tell me.
Compromise the agreement.
Fantastic. Why?
Actually, there are in fact no compromise. As per order 23 rule 3, there must have been a written compromise made. But there is no written agreement is there. And the petitioner hearing had ended about reading only the person of presence of severity of case, his nephew. One
Wait. This is an application under so and so filed by the application and the one. This is an application under order 23 rule 3. Titleship number 1 was filed in the court of the London Municip 1 for declaration of right title interest and so on. And for performer defended by the Imam. The suit was dismissed whereafter title appeal was prepared by the plaintiff. The state appeal was distinct and thereafter defendant appellant filed second appeal. During the defendant, the appellant defendant is to settle the dispute out of the court of the order in this application, supported by a joint affidavit both by the appellant and the respondent. This petition was prepared to pass. for the performing the field and in this application submits his clients are aware about the city is allowed and so and so. Now, what do you want?
My lord, this petition is allowed, my lord. And my lord, as per order 23 rule 3, my lord, that written agreement is required, the mandatory, my lord. But what happened in this case, my lord? In this case, the
Where IAS, no? The IAS.
IA 973, the order is passed.
Here it said the plaintiff shall relinquish his right, title, and interest over the schedule 1, 2, 3 for a consideration of 2,50,000 against which the applicant already paid to the opposite party with acknowledgement thereof.
Petitioner is the plaintiff.
Then?
In the title suit, my lord, the suit
Oh,
was.
wait. It has been filed jointly.
Only in the affidavit, the signature was there, but.
Who is the plaintiff?
Plaintiff is Abdul Jalil. He is not the applicant, my lord, in this IM.
Who is Amin Ali?
Dependent.
And who is Abdul Jalil?
Plaintiff.
So the plaintiff says that he gives away schedule 1, 2, 3, 4 land and he has received rupees 2,50,000.
Yes, but but in fact, my lord, he did not receive any amount. My lord. His signature was taken, my lord, by his nephew, my lord, to conduct the case before the honorable court, but appeared in this affidavit. He is not an applicant in this IM, my lord, and as per order 23 rule 3, my lord, the compromise should be in written, writing, my lord. There is no written compromise is there, my lord. And this
Mr. Kadikari, don't make this type of submission. That the compromise is not on writing. This is the document which is in writing. Then you need to have another document. No, that is not required. This document is enough. But the question arises out here is to whether this particular person has signed it or not. Now, interestingly, why this application is only being filed by one lawyer, the other lawyer is not appearing? Why? When the second lawyer did not file this application? Mr. Ghosh, why only one lawyer filed the application?
But the affidavit has been signed by
And not affidavit. The application was filed by why one lawyer? Because the question arises, an affidavit may be signed. Here these persons did not represent. Who represented? So this application has not been filed by both the lawyers. Those submissions. And this is not a case of review. You want to have to come under 151.
But the lawyer of all sides were present when the order was passed.
It was not filed by the lawyer. How can this type of matter be taken?
Can you see?
But are you okay with this 2,50,000 if you receive it?
Yes, I have not received my lord. Not received.
You have not paid him.
Yes, I have paid him. That is why on that day, sign has been given, and both the lawyer from both sides were present before this honorable court also. And it is not that this affidavit was signed in another place. It is signed before the notary, before this honorable high court. Also.
Who is the appellant?
I was.
Appellant is the defendant. And the suit was decreed.
Suit was decreed by the Gujarat. partially decreed, my lord, partially. Appellate court allowed the.
So the suit was decreed.
By the Your Excellency. My lord, the suit was for right title, interest, declaring possession and cancellation of his deed, my lord. The trial court, my lord, did not decree my right title interest, but my lord declared his deed void, null and void. Against this null and void decree, he did not file any appeal. I have filed an appeal. My appeal is allowed. My right title interest and recovery possession, and also his decree, his deed is null and void decree, but his then my lord, I have come to the he has come to this second appeal. But initially, he did not file any appeal against the trial court's judgment. Where his deed was, my lord, declared null and void. His deed was subsequent deed, my lord. My deed was prior.
What is your name?
My name is Abdul Jalil Lashkar.
Abdul?
Jalil Lashkar.
এই কোন মোকাল যাব ফাইল করছো? Second appeal. And why did you take such a long time to appear? File this petition.
It is filed in time, my lord.
Huh?
20 no, it is filed. The review petition is filed, my lord, in 20.
20. And we are still holding it. Come ask me. No, review kon নহয়. Put to appeal, second appeal. That is sensitive. You put that here. I'm not happy. Let us take it back, please. Which jail officer who appeared on behalf of the petitioner? Respond to you.
Yeah, let's go to council, my lord, the second appeal, my lord. For the.
So now your case is for review. You do not lie, not review. Your case for review is on the ground that have you filed an FIR against your nephew?
No, my lord.
Why? How do you file a review?
My lord, there is a, it is a Supreme Court, my lord.
Hmm?
2018-9 SCC, my lord. Where
19?
2018-9 SCC.
19. Let's see.
In this case, my lord, the review was, my lord, with the Honorable High Court. paragraph 5(6), my lord. 12.9.
How did you know that this compromise petition was filed?
Petition, right?
Filed.
No, my lord, he had gone to the website, my lord, the High Court, to know about his, my lord, status of his case, my lord. Then he found that it is dismissed, my lord. It is withdrawn, my lord. Then immediately he applied to the court within 1 month. After knowing from the website that that case,
So did you not inquire with your earlier lawyer?
where did not respond, my lord. Where did not respond, my lord.
Huh?
The earlier, my lord, the senior counsel was there, my lord, with an argument. And he was the person appeared.
No, when you got that letter, order, Mr. J. Lobscoe was appearing. Did you not inquire with him?
My lord, he did not respond, my lord. The petitioner, my lord, called me, as per my instruction. Then he approached, my lord.
But you never instructed for withdrawal,
No, never.
compromise.
Yeah.
So then how did he appear? When you never instructed?
No, earlier, my lord, earlier, my lord, in the RSA, my lord. RSA, my lord, counsel was, my lord, engaged, my lord, by the, this, my lord, petitioner. But after the withdrawal, my lord, after the, this, decree, my lord, he did not know.
No,
Without
that I know, but at the time when
Initially,
you are being appointed now, take care of it. Tomorrow, when you come up before this court and say, and I have instructions to withdraw, we allow it. Now, on that day, the counsel appeared before the court on your behalf. And he categorically stated that yes, this is the agreement.
no, my lord, he was not the counsel, my lord.
Taylor score is there.
DLS court did not, my lord, did not say anything before the honorable court, my lord.
Why? The
Yes.
order category shows that jail score say.
My lord,
Can you see?
it
Hard
is
Mr. jail score?
HMR, my lord.
Huh? No, you are not read it properly, the entire order, Mr. Gandhi. Can you see the order?
Page number.
Heard Mr. S.K. Ghosh, the learned counsel for the appellant, and Mr. J. Losco, the learned counsel for the respondent, opposite party number 1. Mr. So-and-so counsel also representing all the pro forma opposite party is present.
Yes, Chairman. But
It's
jail officer-
okay, but
jail
the
officer
fact
not-
that jail Oscar was there,
Yes, sir, he did not, my lord, consider this, my lord, idea, my lord. That my consent was about, or I have, my lord, entered into an agreement, nothing is there.
I think he was appeared and in
He
his
appeared.
presence the order was disposed.
Yes, sir,
Then
but nothing, on behalf of him, my lord, is recording order, my lord.
what is required to be recorded? You did mention what Mr. S.K. Ghosh has stated. It is mentioned.
It is his application.
Not,
The
both of you have signed.
Yes, in the affidavit signed, my lord, but he is not a part of the applicant, my lord. In the affidavit, his signature is there, my lord, and the petitioner's signature was taken, my lord, blank by his nephew, my lord.
So therefore, the question is, have you inquired with Mr. J. Oscar?
Inquired, my lord, as per instruction, my lord, but he did not respond, my lord. It is my-
Did you file any bar council complaint because he didn't read so without your instruction?
As of date, my lord, instruction is that no complaints.
No, the question is very serious because this is a very serious aspect.
Yes.
Tomorrow you want to withdraw a case, we do it on the basis thereof. Now tomorrow this person may very well say, now if you have not taken any action against Mr. J. Oscar or not reported to the bar council, not taken any action against the refuse, why should we believe you? Tell me, why should we believe you? We can only believe you provided you take some action. You have not taken any action. You may be right, absolutely right. But the fact that why should we do so? It's a case of fraud, what we are saying. We are saying that this person has signed it out there like this. Secondly, you have not taken any action against Mr. J. Oscar. Why have you not taken?
I have to take instruction.
You take it because this is a serious thing. What you are saying has far-reaching consequences. The moment I hold it like this, then every time a person wants to withdraw, I'll ask that person to be present here in the court. Because that person will very well say, then no, I have not been instructed to do so. Then the faith on which normally what happens in the trial courts, the court does not permit withdrawal or compromise decree or even withdrawal without the presence of the parties. Okay. Now in the High Court, we permit with both the lawyers being present, we trust it. Are you suggesting that henceforth, whenever all lawyers submit out here that we want to withdraw, we'll ask that person to be present? That there has to be some trust upon the lawyers. Did you inquire by yourself with Mr. J. Oscar that this has happened? What do you say? Then, because if I allow this, I have to hold that Mr. J. Oscar had appeared on behalf of the AR for other vested reasons. I'll have to hold this, which is going to affect him. Unless, yes, in a serious case, you may very well, but you have to take action. So who, both of you, let me do one thing. I'll send you along with Mr. J. Oscar both to the bar council. Refer, fight out, both of you.
Obviously.
Huh?
Each time may be granted, I may take the instruction from the client.
And if you have not got that 2,50,000, then you file a suit for fraud. You see, here the Supreme Court says two things. One is a review. Yes, there's some mistake out there, some compromise decree review, that can be. But if it is a case of fraud, which you are trying to allege, suit is maintainable. But you can't really review for that. Review is for that, okay, there are other aspects which are there. But if it is your specific case is that your nephew has taken the signature, I don't know anything. You never instructed your lawyer. Nothing was done. And it's a very serious allegation which you have made. What?
Next time maybe.
How much time? This time, the learning council appearing on behalf of the petitioner submits that he may be given 2 weeks' time to obtain instructions as to whether the petitioner, as to whether the instructions. The instructions have been sought for on account of the query being made by this court as to whether the petitioner herein have filed any complaint against the counsel who represented the petitioner before this court when the compromise decree was passed. The instructions have been sought for as on the ground as to whether the petitioner have filed any police complaint against his nephew for wrongfully taking his signature in the paper as alleged in the review petition. This the matter again on. Let it be behold, one day before behold, 11th of July. Let the another judge also see. That is why I made it very specific. His instruction is to be 10. Well, not 11, 10th of it.
10th of. Item 11.
But what you are saying is, you won't believe anybody. You are saying that we won't be believing anybody, all lawyers. Very serious concept.
On 10th, and it is on 10th.
10th. 10th of April.
Any other paper?
10th.
Item 11.
Here's what is this.
Order number 5 and 6 have filed their affidavit. I have filed my reply to the others have not filed their affidavit.
What is the matter about?
This was regarding a promotion to the post of process server from the
Listen to the poster?
process server, my lord. In the civilian establishment of Bogota. But I was denied a participation on the ground that I was not HSLC passed.
You did not?
I was not HSLC passed. I was serving in the gate 4, the draft rules 2018. They said that for the promotion, I need to have 5 years or so. No question of an education of qualification. I was denied that, saying that HSLC was a required qualification. I approached this honorable court. This honorable court has allowed me to participate, kept the results on book, and notice was issued. The learned CGM has now filed an affidavit saying that the recruitment rules which I gave with the petition may not be the correct rules, because he has another set of rules which was given to him by the head assistant, which shows that HSLC qualification is required. I went through the records. Affidavit has been filed in another matter by the registrar of the Guwahati High Court, where HSLC is not a required qualification. So this would require a clarification from the registry of this honorable registrar. What is the actual rule which was required to be applied? Because if, as I say, HSLC is not required, then I have a very good. If HSLC is required.
Process server, HSLC not
Not required. For the affidavit of the registrar of this honorable. May I place that for a moment? If Lordship has my.
No, not required. But they have filed an affidavit.
The CGM court has, the CGM has filed an affidavit, but the registry of the Guwahati High Court has not. That
No
will be
High Court.
required.
No High Court, lawyer.
Sharma was appearing in the matter.
Oh, Sharma is appearing. Okay. It seems that the affidavit has not been filed on behalf of the Guwahati High Court. Hey, don't recently. No. It is really should have said that we listed of the billing, no? It seems that the Guwahati High Court has not filed the affidavit, although an affidavit has been filed on behalf of the CGM, Chief Judicial Magistrate.
Five and six are filed.
It's the matter again on some of admission.
Orders. Because respondent number 7, my lord, the private respondent was appointed, his 14 years junior to me and as in promoted.
Affidavit in rule 5/5/6. Okay, response number 5 and 6, affidavit 5. Now this post is vacant.
My lord, there were two posts. One was, one of this respondent number 7 was already appointed. The other is vacant. The interim order protects my position to some extent.
So there's no. Waiting list, the petition, this person has already been appointed.
So what has happened is there was already a selection process where I was denied. Before I could come to the court, they had made an appointment. So at paragraph 13, my lord, it has been made subject to upon the petition. And the fresh process that they had started, not to appoint without leave of the court. The results will not be declared without leave of the court.
Which one?
Para 12. There were two processes. Para 12 and 13 of the order passed on.
Okay, that is when the
2020.
last proof for submission is having. So this is stalled.
No,
this
with leave of the court, they can proceed.
Huh?
If they want to proceed, they can proceed with the leave of the court if they make an appeal. As per para 12.
Hello.
And 13, it is only subject to upon appeal. So
Okay,
nothing.
it's okay. So as the affidavit, you want to file a reply?
I have filed the payment.
File the reply today.
Perhaps it has not come on.
The Arvind submits that the council appearing on behalf of the petitioner submits that an affidavit in reply has already been filed on against the affidavit in opposition file will respond number 5 and 6. None has appeared on behalf of the Guwahati High Court. None has appeared on behalf of the respondent number 2 to 6 in the instant proceedings.
6 appeal.
I want.
But we are way appeals on behalf of the respondent number. It is not known as to whether the respondent number 2 and 3 would like to file an affidavit. Just taking into account above this matter on 25th April 2025. In the meantime, the respondent number 2 and 3, as well as the respondent number 7, are given the liberty to file their affidavit if they are so advised by 21st of April 2008. Hearing, who's the matter hearing?
Number 14 is there.
Hearing? What is that matter?
Regarding fixation of pay as per revision of pay rule. Initial fixation was wrongly done. The High Court has communicated to the authority. That has not been done.
The listed matter again on 24th. 24th April.
Of like,